And we're live. Welcome to Warrant. Madam Clerk, would you please take our attendance?
I will. We have Dave Humphries, Tom Caldwell, Lori Crowley, Jake Buckley, Allison Gagnon is on Zoom, Julie Joyce is on Zoom, Kristen Kruskil is on Zoom, Jerry Laylight on Zoom, Timothy Lyons on Zoom, JJ Connor on Zoom, Steve Ryan's here, Sia here, and Judy's still here.
Thank you. I declare a quorum. First meeting on our agenda. Let's talk about the open meeting law complaint that was filed against the Warrant Committee, alleging a violation of proper posting of notice as required of the Warrant Committee meetings on October 11th, 2023, and again on October 18th, 2023, with regards to the proposed warrant articles. One, to establish a local historic district commission in the local historic district, which I have now put in parentheses, Milton Village. And the second one, to transfer parcels of land to the Conservation Commission. I have now put in parentheses in the vicinity of Cortlandt Circle, Thistle Avenue, Whitman Road, and Riverside Avenue. I have given all members of the Warrant Committee a copy of the complaint, this alleging as such, for your review. I've also given copies of the open meeting law complaint form, which lays out the instructions for a public body that receives a complaint such as this. The first is I have to disseminate the complaint to the members of the public body, which we have done. Then we must meet to review the complaint within 14 business days, usually 20 to 22 calendar days. And shucks, if we didn't get right to it, because I think I got this thing and pretty much handed out right away. It's being, it's important, right? Open meeting and the public being on notice of what we're doing here and our important work for the town is fundamental. Okay, so then after a review, but within 14 days, we must respond to the complaint in writing and must send to the Attorney General a copy of the complaint and a description of the action the public body has taken to address it. And we must send a complaint and a copy, and we may delegate the responsibility to counsel or a staff member, but only after it has met to review the complaint. So I've given it to everybody. I've asked you to review it. I'm going to ask you to let me respond after we review. I do the notices. I do myself. I type them out. So if there was an error that was made here, it was made by me. Okay. And I think that what I did is that when I gave the notices of these meetings, issues that we were to discuss, the issues that we were to discuss as I saw them were these two articles. Now, we're required by the open meeting law to be specific with regards to the issues that we're going to discuss. So because we had two articles, each article being a single article, one only, I felt that that was specific enough because I was referring to only one possible thing, the article. I think what's happening is that the allegation is that's not enough because we didn't identify one with regards to where the historic district is, identify where the historic district is. And the second one with regards to the transfer of land to the Conservation Commission, we didn't identify the vicinity of where that was. So we might as well, right? We might as well. We might as well be more specific and give the public, though I believe that our notice was adequate, we're not here just to meet the bare minimum. Might as well put it in. I did notice that when I went back and did some review that the select board, when they were talking about their article with regards to the historic district, was using in parentheses Milton Village, right? Sort of taking some a lesson learned from that is I figured might as well with regards to the conservation land. I went back and looked at the map that we had on the website along with our materials from the meetings and identified the roads that were there. And so like for tonight's agenda, those changes that I identified, I felt might be appropriate, have already started to institute that. So with regards to these items that we're having tonight, I've already started to do that. So that, and we would carry that forward. Okay, we would carry that forward and continue to do that, so that we can have the very best notice and agendas going forward. So that's what that's what I've done so far. The other thing is this: is that as part of the complainant indicated that this could only be cured by reopening that meeting and voting again. I'm not sure if that's actually the case. I'm not sure if that's the case. But I figured with regards to that, we might as well. Is that I did not put that on the agenda for tonight because I did not put that on the agenda for tonight. But we did file an agenda for Wednesday. So that article is back on it. Because that did pass unanimously, I figured that it would not, and my sense is that we had a commitment from the Warrant Committee on that. I think that if we did that, we can have a debate, we can open that up again. But I don't think that would be too onerous on our time. In an overabundance of caution, I think I disagree with our need to do that. But in light of dotting all the I's and crossing all the T's, I might as well. Okay, so that is what I propose. That is what I propose. Does anyone have questions, comments, other point of view?
So is it, I didn't check Wednesday's agenda. Did you indicate just now that it will appear for Wednesday's agenda to reopen?
Right. So I think
Yeah.
I put it down as like discuss and vote. So the language that we use on those things, right? Discuss and vote, and so that we can go back. And I think that will end up being like sort of a ratification process. Ron.
So we could have a discussion within the Warrant Committee. Would we invite the guests again to present their case yet, or could we just discuss?
I mean, I would reach out to them, let them know what's going on, that we're doing it again if they want to. I don't think we would need a re-presentation unless anybody wanted it. I think I would let them know, like, I don't think we're going to talk about it. If we wanted to have a re-presentation or additional, we could. At this point, I don't think that would be necessary, given the fact that it was unanimous. And then if something happens and all of a sudden we check ourselves as some unexpected, we don't have to rush to a vote. But Tom.
Yeah, and Mr. Chair, more of it is a comment, but I think the central issue regarding the complaint is public notice, right? And that would allow members of the public, I think, to come in and be heard by the committee. So it would give those people an opportunity from that neighborhood,
Sure.
that we know very well, to come in, be heard if they
Sure.
so feel,
Yeah.
and then we can discuss. But I would say that a re-presentation of the materials would not be necessary. I think I agree
Right.
with Ron.
Judy.
To Tom's point, we don't have public comment, so
Well, yeah.
although anyone can sit in the room and certainly watch us live.
Right. Well, so that's true. And we don't have public comments, but we do have a history if there's sort of what I call like stakeholders. So like if there's a person on Thistle who just looks out at the river every morning and says, someday I will have my asphalt plant, this is their chance,
Okay.
right? This is their chance.
Yep. So they would have to
I mean, if there's stake,
just
and that happens, I get an email. I often will get the email from someone who says, we're neighbors, so it's so if, we have done that. where if someone's what I call, a real stakeholder, maybe somebody who represents their neighborhood or something like that. So again, while we don't hold public meetings, right? But sometimes there's people whose stake in the issue, so. Okay, does that sound appropriate? All right. Thank you. Moving on to the next agenda, and that I have Mr. Lawfer. If you could join us, please. What we had done is, let's see, the next item on the agenda is discuss and vote upon the proposed warrant article to establish a local historic district commission and a local historic district in Milton Village, right? At our last meeting we had at the warrant committee discussed that we had some questions and there was issues that we would like to have addressed. Over the weekend, Mr. Lawfer and I, we had a phone conversation where I think that we agreed that maybe what was best would be that if some more time was given to this issue, and that if we took time to work on the article together and maybe come back at the annual with a more polished version. Is that accurate, Mr. Lawfer?
I'm not quite sure of the timeframe. I'm hoping that at the December meeting that we actually vote on this. But you're suggesting that we just come back with an article at that point?
What I would suggest is that at this point, going into December, that we make a recommendation at the special in December that the article go to the local, let me get it right, the local historic district commission or the study commission. You are the
Local Historic District
study committee. Right. So, yep.
That's who we are. There are 5 members, spent 2 years studying what we should do, what's historic, and why we should do it. And we have had our proposal accepted by the Mass Historic Commission. Right. And we have been supported by the Planning Commission, who I've presented to. And we did have some specific concerns here at the Warrant Commission when I was here. Was that just last week?
It was.
It was. Deja vu, right? And I came back with some answers related to that. Now, Chairman Humphreys and I did have a conversation, and we did agree that in my committee, we have an attorney, Andrew Huffman, who can't be here with us right now, but does agree that Chairman Humphreys, myself, Andrew Huffman, and I believe Jay is going to be part of that.
I'll volunteer you if that's okay. Thank you, Jay.
Because Jay had the original questions, and that we would work out the very few, very specific things that need to be finished.
Right. So what I took away was that to do that, we can do that. But my concern is that we're not going to have time to get that done for the December town meeting. Is that what we might ask for is for a vote here for the matter to go to the LHDSC for further review and drafting, so that we can then, prior to the annual, bring it back for what we would hope would be a vote for recommendation from the Warrant Committee that in together with, because you've been at planning and select board, then with the recommendations from everyone, that then we could present that to the town at that point. But it sounds to me like you took away from our conversation that we could do that for this town meeting, this special town meeting.
Yeah, that is my feeling, that we could do that. Listening to what the this committee had to say and where we are, there's very few remaining sticking points, and I'm here to address a couple of them, which we haven't gotten to yet. The main sticking points.
Okay, what was the main sticking point in your opinion?
As I remember, the opt-in and opt-out. And I was absolutely incorrect in suggesting that someone in Milton, if we pass this, or I should say when we pass this, that each of the 40 property owners that are in Milton Village have an option to either opt in or opt out. They do not. They do not have that option for a local historic district. That option exists at other levels, and it does not pertain to what we're doing here whatsoever. And the other issue that was outstanding, I think, is not an issue for my particular committee, but for the next committee. And that was brought up about fines and how we levy fines and do that. That has nothing to do with my committee. We are forwarding all of the proposal with an outline for the possibility of fines and retribution. And we don't determine that. The next group does. And I'm not sure what that's going to be termed or named. Local Historic District, We Gotcha Committee, I don't know. But they are going to determine, I'm sorry, I'm being a wise guy. It's not appropriate in this situation. It's going to be a second committee, and that second committee is going to write all of the aspects of how this is rolled out within the town. But there's absolutely no confusion that Milton Village is the absolute best place to do this. And that's why we think we could meet at your earliest convenience and hash out these couple of different things. Now, if that doesn't happen and we get pushed off, then we're pushed off. Those long-suffering volunteers will go 2.5 years. But that's not a problem. I've spoken to all my committee. We're here to get this done and get it done right.
Okay,
Oh, you're the Judy. Now I know. Now I understand.
yes, Judy.
So I was going to ask the chair if there's going to be any further comment from any of us, if there is.
Well, yeah, I mean, if you have a question.
Cliff notes, you got it. Okay, yes, I was the one that made a lot of phone calls about the opting out research. Okay, so here's a question. What outreach has been done to all the property owners in regards to the fact that they are now included in a proposed local historic district?
I can answer that.
Sure.
There was a letter that was approved by Mass Historical and our committee, and it was sent out by the town to the 40 property owners last week. We have as per requirements. And as per requirements, we're going to have a public meeting with this on November 6th.
May I continue on that same road, Mr. Chair?
Sure.
Okay, so here's just the view from my front porch, which will never be in a historic district, but however, is meaningful for this town. It would seem that this committee had already been to the select board and to the planning board prior to this letter going out to these 40 property owners. So my question is, what took it so long to get to the people that are going to be the most affected by this overlay?
I can answer that. As mandated by the rules at Mass Historical Commission and that we are following, we had to first create a proposal, and that took 2 years of exhaustive study. And then our proposal was presented to the Mass Historical Commission. It was accepted. And then at that point, the letters go out. This is mandated by the state, and we followed those guidelines. So those people were reached at the absolute first opportunity when it was mandated. And now we are in our public speaking phase, and we are getting more information from those people. A survey was sent to each of those people, and all of their responses are due back November 4th, I believe, if that's not a weekend. It'd be the 5th if it is a weekend.
I'm still on that same road, looking for a rest stop. I'm almost there. So, after the warrant is in print and making its way back for distribution in our town, the very first public forum, it seems to me like the cart before the horse. So I understand that there's a mandate to follow procedures. You have to do this first, this second, this third, this fourth, this fifth, which leads me to ask this question. Do you really believe this is appropriate timeline for this historic endeavor of our town? Not leaving enough time for letters and public input, especially those that will be impacted. There was a question. Do you really feel that once it's in print, heading off to the town meeting, oh, well, we're gonna have a public forum?
Again, Judy, I am following what has been dictated and followed by all of the 200 towns that already have this in place within their towns. Lincoln, Harvard, Brookline, in specific, have done this along the same timeline. And so that timeline has been accepted within the state and within all of the communities, the 200 or so that have done this prior to us.
Right. I do agree that everybody has, probably followed all the rules and everything. Otherwise they wouldn't have their historic district. I feel for us that squishing this is, we'll just say at best, not neighbor. They are our neighbors, all these 40 people that own property.
Do you have any further questions, Judy?
Sure, let me go through Cliff. Here, almost there. So you don't even know the results of the survey, would that be correct?
No, we've done several surveys, Judy, and we have all of that information available
Okay,
to
the
us.
information about all the surveys that you have done, what percentage of the 40 people are in favor of this overlay?
I'm sorry, you need to ask that question again.
Okay, I'll make it as direct as possible. If you have other surveys that you have you, what is the percentage of in favor for the overlay?
Pretty much overwhelming. In fact, there has been I can't remember any pushback. I have pushback on some questions related, but there's been absolutely no pushbacks from anyone in any of the surveys.
So would you say it was 100%?
I would not say 100% because I don't know the percentage, but I would say the vast majority of them, 60, 70, 80%.
Is that correct?
Well, he's doing
I
the
don't
best he
have the
can.
numbers.
He's
I
doing the best he
wasn't
can.
expected to
He's doing the
answer
best
this
he can.
specific question.
Okay, very good. When you went to the planning board, this is a direct question, when you went to the planning board to present, did you present the results of any of these surveys at that presentation?
I did not. They didn't ask. All of these surveys were online and it was on the Milton website.
Is there some reason, in direct question, is there some reason we don't have a copy of any of those surveys?
Perhaps because you didn't look at what was on the town website when it was there. I believe all that information is still up there.
So we should get it? That's a question.
Well, if it's there, you go on the,
I would
Jay,
say,
can you, Mr. Chair, I'm sorry. Jay, would you be able to find that? Would that be
I
okay?
don't know how quickly, I don't know.
All right, so.
Rob Mallett can get you that immediately.
Okay, I think she's wanting me to look at it like right this moment.
It's on the website. It's on our local historic district study committee. It's in our notes, meeting notes.
Is there any land that can be exempt from these historic regulations?
Not once it's approved. Once it's
That is
approved,
incorrect. If I may make a statement, government land can exempt them from historic regulations. I have that in writing. Okay, I guess the point of some of my questions here.
well, Judy, wait a minute.
Go
Wait
to
a
the
minute. You
fact
just,
that-
I'm sorry.
Oh, that's
A point of
discussion,
order?
that's not
all
question.
right,
You
hold
are
on,
right.
just,
You are right.
A point of order here.
okay.
She just said something was incorrect, and that's just patently not true. So you need to be accurate.
Print it out for you.
All right. At this point, I'm going to respectfully ask.
I'm done. Thank you very much.
Okay, thank you. Do we have any other questions? Steve?
Just an observation. So I live in East Milton, actually a historical district, railroad village.
Yes.
My observation is that there's a tremendous amount of pride with folks
Yeah.
having some signage throughout the area.
Yeah.
To represent history. There's a lot of great history in Milton, so it's just an observation.
And I absolutely agree with you. One of the questions that we had is we're 200 plus years now when we're 300 and 400 years. The railroad district in specific, and that's why I talked about it, it was so important during that time and should not be forgotten. But it doesn't need to be an historic district.
Correct.
Because it is protected within our, same with the Milton Cemetery. That doesn't need protection.
Jay?
Yeah, I'd just like to raise one thought I had after last week's meeting, which I guess is relevant to our discussion now because it would have made me question if we're going to be able to accomplish this tonight. And it also is maybe something we can keep in mind if we're getting ready for next time. You, I believe, gave the example of insulated windows. And I'm paraphrasing, and I'm sorry if I get this wrong. I think you said something like, well, insulated windows aren't historic, but of course the committee would say yes to that because they're good. And then I believe you said, be sure to put good people on this committee. And that just made me nervous because for two reasons. One is, you might not get good people on the committee, or you might get excellent people on the committee who are super virtuous and knowledgeable. But if the question comes up, can we put up insulated windows? They might not have any guidance of approve that, don't approve that. And that's sort of and then there's the unknown unknowns. So I don't know, and maybe you could relieve my fears by pointing to other towns and how they've done it and how it's worked out. Or there are lots of ways you might relieve my fears. But when I hear someone say, this is going to work if you get good people on there who are going to use good judgment, I get nervous. I get nervous a lot.
Oh, yeah. And without naming towns, I had that discussion with the people at the Mass Council today, and some towns are not doing it right. We seem to be following the correct guidelines, and that's why it was suggested I speak to the people at Lincoln, Harvard, and Brookline,
Okay.
who have gone through this. But you're right, we're volunteers, and volunteers can be, all of us sitting in this room. And depending on and the people who are watching here, who are making sure that we're sticking to all of the correct information. We want to do our best job. And I have to believe in that. I have to believe in my town members. And if they're not of that caliber, then we have ways to deal with those.
Yeah, there are appeals and things, or no matter what caliber they are, if maybe they need more guidance, or maybe you can reassure me that they don't need more guidance. Or
the ones that were discussed were towns that were divided on where they were going with this, and our town is not, and we haven't, because we put in the due diligence way before. We weren't trying to force anything. We were trying to find the right solution for this opportunity.
Okay, thank you.
Ron?
The discussion we had last week, the opt-out portion was confusing to me. So thank you for that clarity. I think that was one of the bigger issues I had.
I was confused on that issue.
One of the things that Judy asked, you were answering about following the timeline from Mass Historic. Do they typically recommend that the public outreach happens without enough time? Like in our case, it feels a little uneasy that there are property owners being affected by this, and we haven't heard from them. We could go to the public forum on November 6th, yet we've already made a decision and it's going to town meeting. So is it their typical process that there isn't enough lead time before a town meeting adopts it or city council adopts it? Or is it standard that they hear from the public before it goes forward?
We jumped the line with this because our proposal was accepted quickly. And so the moment it gets accepted, the state has 60 days to get back to us. They got back to us in like 5 days, and we moved through. So we actually gave the public, according to the regulations, information earlier. And so it's like 60 days, 30 days, 45 days, kind of the programs, and we're right there where we're supposed to be. And we also have that survey that went out to those people. And I should have brought that survey, but I can get it to you, Dave, to share with the committee. We asked 5 or 6 questions. Is it important? Do you understand what an historic district is? Do you understand the benefits? And is it of value to you? Those kinds of very ballpark kind of questions to let them know that this was going on. And the letter was really very specifically written, not to be, hey, we're doing this to you. It was, hey, we have an opportunity to protect this particular area. Milton Village is not an area that's protected in any other of the situations. It's not federally or state-wise. Now, Baker Chocolate Factory and a couple of the things are in the historic district. that's a building. That's not the area. It's the area that's important. So it does feel quick.
It does, yeah. I'd like to hear from the residents.
And if we get pushed back, we get pushed back.
Judy?
With the MBTA zoning bearing down on us on December 4th, does that have any bearing on this rush job? When it could be done 6 months later, having thousands of questions answered, and plenty of time for feedback.
So I don't think that's a question for Mr. Lawfer. Why don't were there any other questions for Mr. Lawfer?
Yeah, Ms. Laffer, if you could, for us, of the surveys that you have received back, could you just give us a general flavor of some of maybe responses that you've received? And when I say, any adjectives or like anything that the people have, just
the conversations that I have personally had, I can speak to. Most of it is, how is this good for me? How is it bad for me? Those are, what should I be afraid of, or what is my benefit? Is most of the conversations, and the benefit is, by stating this particular area for all of those people, is that we keep the fabric of this community alive for another 100 years. And the fear is that, number one, my values are going to go down, and we have proof that that's just not true. Your values go up if you're in a historical district. The other is, you're going to tell me to do things that I don't want to do. Again, to the windows or signage or any of that. All of that is stated in there. And that, again, is the next group, but we had lots of conversation about that we did not want to be a town that was dictating to our homeowners and our business owners how they should run their businesses, live their lives, live in their homes. What we did want to do is make sure that we protect the facades, the buildings, the quality of
general character of,
the character
of the area. So it's not something as, I love Beacon Hill, but we're not talking railings and,
right.
Mailbox colors, are we?
Exactly. None of that is from our group.
Correct. Okay.
Is in there. In fact, it's actually stated that we're not interested in doing that.
Is there anything more maybe you could share just in terms of the residents from the area?
The surveys were like all over the place. Whenever you put anything out in the public,
sure,
people who happen to run across it will answer it. Some of those are of value and some of them aren't of value, like most things on the internet. But we did have some questions along the way that were helpful to us. Have you thought about this, or have you considered that? And in several of those cases, we hadn't. So then we addressed those. For instance, the history of the town. High Street was a more important street than Adams Street. And we weren't aware of that. And some historian who lives there was aware of it and brought it to our attention.
Thank you.
Again, it's my sense of the Warrant Committee that there's strong support for the article, that it will eventually go to town meeting with a recommendation as per the other recommendations. I think it should pass. We just have to move that ball from the 3-yard line.
It's never the intention. I don't think it's good governance or to do things too quickly. It's better to do things correctly. And My feeling, because I've been with this for 2.5 years, is that we have done that. And so I want to move forward with it, but that is my feeling. And if that's not the feeling of the committee, because you haven't been with this for that period of time, or to Judy's point, the 40 people who have gotten this letter, if they have questions, it might take them longer than a week or two to say, wait a minute, how is this? Or they'll think about it and then they want to come to it.
So I think the next step, I think we will communicate in the very near term. How if I call you tomorrow?
Yeah, absolutely. And Andrew, he was sorry that he couldn't be here, but he is ready to do this.
Okay. It's my sense that we should table this or suspend this discussion to the next time it appears on the agenda. In the meantime, I will reach out to Mr. Loffer and we will start doing our review of the drafting. Jay?
So you think this will come back up to us before the warrant goes to print the 1st of November-ish?
It should. But if it doesn't, it doesn't.
Well, I mean, because we have to make a recommendation of some sort.
I know. I mean, so
I'm just
there's a
saying.
disconnect. I took away from our conversation that there was an agreement that we would be referring this back to give it time for the annual. That clearly is not your recollection of our conversation. So I don't want to.
Could I make a suggestion? Let's have the meeting between the 4 of us
And see where it goes.
and see where it goes.
See where it goes.
And if you feel and the warrant committee feels,
Right.
we'll
And it's not because we want to deal with each individual issue as each individual issue.
Yeah.
And what it's true is that we have a big orange trolley that's just bearing down on us that we've been waiting for. And so anyway, I'll call you tomorrow.
Okay.
I don't want to be an impolite host, but as 1/15 of the warrant committee, it's my opinion that I'd be pretty surprised if this was in good shape by the time it went to print, partly because I feel like if we clean up the things we discussed before, then we'll have the real questions. Like we need to clean up all those things that we discussed before to then get into it. And then even would we be asking the select board to reopen, because what's going to be printed in the warrant? What will be printed in the warrant now is what you submitted, which needs a lot of work.
Needs to be corrected.
So I would be very surprised, I think we're close, but I would be very, very surprised if we were in good shape by the time the warrant went to print. So I don't want to make a motion that's out of order, but I would. All right, I'll zip it for now because one of our other members wants to speak.
Jay, I'm going to help you unzip, okay? Whoops. That's on TV.
My mouth.
The mouth.
Zip the lips.
The lips. Correct. Correction. I'm going to make a motion. For a no recommendation from the Warrant Committee for the special town meeting.
Can I make a friendly amendment?
I'll entertain that.
Okay. Maybe we want to recommend that we send it back to the fill-in-the-blank committee for further study.
And I do agree with you. No recommendation to send it back. Correct. You're right, Jay. So we needed to add a few more words into that motion.
Well, not even a no. I mean, that's just,
Doesn't it mean the same thing?
It means the same thing, but we're not saying vote no. We're saying,
Well, I'm not saying vote no either, because this is a very worthy,
oh, you're saying
it's a very
it gets into
worthy-
confusing no recommendation
Yeah,
versus
right.
no recommendation.
Right. Well,
Okay.
What is the correct?
So I think what you
wording of
might
the
be
motion?
saying is, yeah,
Right. And this is a very worthy article for this town.
yeah. So
And
that we're
it
recommending it be
needs
sent back
a
for
lot
further
of
study.
worthy thought more to get it into town meeting.
Mhm.
It needs to go into town meeting correctly with a lot of, so would you feel better
Okay.
if my motion said, no recommendation, that we feel it needs to go back for
It's just a little,
further? What would
help me out. It's just a nitpicky town meeting thing. It's our recommendation is to send it back to the local historic district study commission for further study.
Further study.
So it doesn't have the word no in there. Yeah.
Yeah, there's no, it's just a friendly,
I mean,
Our recommendation is
Gonna
to
go
send it
home.
back to the
know what
local,
it was.
to this committee for further study.
Okay, well, my motion,
And I
With-
second that.
thank you, Jay.
You're voting to recommend the article be sent back to the committee.
Yes.
For further study.
Yes.
Would you please conduct a roll call vote, Madam Clerk?
Jay seconded.
I did.
Okay, Tom,
yes.
Lori? Yes. Jay?
Yes.
Allison?
Yes. Yes. Yes.
Allison?
Yes.
Welcome back.
Can you hear-
Joyce?
Yes.
Kristen?
Yes.
Doreen?
Yes.
Tim? Tim Lyons?
Yes.
JJ?
Yes.
Steve Rhines?
Yes.
Amanda?
Abstain.
Ron?
Yes.
Judy?
Yes.
We'll go back to Allison
Yes.
and Dave.
I abstain. Okay, so that's the recommendation at this time. It would be that it go to the LHSDC,
I like when you use the acronym.
right? I'll call you tomorrow.
Perfect.
We'll start immediately.
Okay, so November 6th is the local historic district study committee next meeting, and it's the public meeting. I'd like to have this worked on with the Warrant Committee and us before then.
Sure.
Because this proposal was accepted by the state. We're making adjustments based on what the Warrant Committee is asking, good questions. It's still a very viable proposal.
Yes, indeed. Tom,
Father, where is the meeting? And is it on Zoom? Is it in public?
It's going to be in public. I believe,
But
face to face.
But on November 6th, do you know?
On
the
November 6th,
Do you know the
it's going to be at
location?
the library.
The library.
sounds like a Keys community room event to me.
Yeah.
Certainly.
Maybe
Thank
these
you.
guys will be there. The tech crew.
Thank you.
Thank you.
Thanks.
Last time you dismissed me and then you went and talked. Are we done with?
We are indeed. The matter, this agenda item is closed.
Perfect.
Thank you.
Thank
Thank
you
you.
very much.
Thank you, Jeff. Folks.
Next, we have town council with us. So I would like to ask our Attorney Mello, would you please join us?
Sure.
Thank you. I know you, Peter, thank you. Pete, great. There's Davids and Daves. I am definitely a Dave.
Okay.
So I can appreciate the Pete. Thank you for coming. You know, like we previously, like I just said, is we've got this orange trolley that's coming at us. And we're about to do our part in the MBTA zoning issue that is happening now. Right now, the planning board is meeting right now to discuss, Monday, no?
I think it's tomorrow.
Tomorrow,
Yeah.
5.
Okay,
At 5?
huh?
They're meeting tomorrow before the select
That's
board
right.
meets.
Before the select board meets.
So figuratively now.
But, right.
Sure.
In the midst of
Right, it is all one now.
Okay.
This is the warrant committee continuum. Let us go there together. Okay. Right. So just think about that. Planning board and select board are basically meeting back to back. So the planning board goes in with an article, 2 articles, no articles, who knows? Then the select board votes probably on at least 3rd iteration of their article that's been really worked on by the planning board, right? So they initiate that's coming back. Public meeting of the select board article at the planning board on Thursday. And then that's where we come in, probably next Monday, Tuesday, Wednesday. But as a sort of threshold question that had come up at the warrant committee, and so we've asked Pete to be here. I had asked, we had asked for some guidance on the issue of the question of compliance, right? So what I'm going to ask of the warrant committee tonight is, can we please keep this discussion sort of focused on that? Pete, we've not asked him to brief up on the legal issues, of which there are numerous and sundry, a multitude, right? So we would not expect him to come and give us legal opinions on each and every little aspect of this very, very, very complex issue. But we had, amongst ourselves, felt that the issue of compliance was something that we would like to hear about from the very beginning. So I would ask, please, for your perspective on what is compliance? What does it mean? What does it mean to be, if you're not in compliance? What does not compliance mean? Mm-hmm. What are the penalties for not being in compliance? And how is that enforced? So if those are some of the things that you could please keep in mind, we're all ears. Thank you.
Sure. No, I'm happy to. And a lot of this was the subject of a recent opinion letter that I prepared for the planning board, along with my colleague, Karis North, who is really, to whom I defer on MBTA communities matters substantially. She's one of the state leaders, in my view, on these issues. She was at the forefront of the team of municipal attorneys whom the Mass Municipal Lawyers Association kind of organized for purposes of vetting the legislation when it was, just being proposed. And so it's very helpful. She's a great resource to have with respect to this issue. She and I prepared an opinion letter to the planning board that I think summarized pretty concisely and well exactly the issues that you've inquired about, Dave. I know I sent that to you. I don't know if you sent it around to the group.
I can report that I have. Thank you.
Oh, sure. And so basically, I'll call it HLC. It's the Executive Office of Housing and Livable Communities, formerly DHCD, promulgated guidelines in accordance with explicit statutory authority in Section 3A. So the MBTA Communities Act is 40A, General Laws Chapter 40A, Section 3A. It's a few paragraphs long, and relatively speaking, particularly compared with other provisions within the Zoning Act, it's pretty pithy. In that few paragraphs of text that explicitly conferred upon HLC, along with other agencies, the authority to promulgate guidelines, what it called guidelines, to determine compliance with Section 3A, with the Act. HLC did that pursuant to the guidelines. Proposed bylaws or adopted bylaws are sent to HLC for a determination of whether they're compliant with the guidelines and with the law. So basically that's compliance. In terms of enforcement mechanism, the Attorney General's office is charged with enforcing, violations of the Act. The AG issued an advisory that summarized some available enforcement mechanisms. That was attached to the memo that we did. And in addition to explicit statutory mechanisms like, ineligibility for certain funding, the AG cautioned or emphasized that it could also pursue civil enforcement for communities that don't comply. In other words, the statute makes reference to certain funding opportunities that a community that doesn't comply with the Act would be ineligible for, and the AG, I think, pretty decisively emphasized that that language isn't intended to suggest that you can decide to forego those types of funding opportunities and just not comply. That the statute does mandate compliance with the Act's terms. So. I know you, Dave, you raised a question about the distinction between guidelines and statutes and regulations, and that was covered in the memo that we did to the planning board. Basically, there were a couple of cases that I mentioned during the meeting with the planning board where courts have underscored the deference and have used phrases like substantial deference in underscoring the deference that courts accord to guidelines. And in this context, I think that that in the event of a legal challenge, it's my judgment that a court would be particularly inclined to accord that type of deference with respect to these regulations because of the reform, nature of the legislative, the impetus for the legislation in the first place. It's sort of reform-oriented legislation. There's case law to suggest that where that's the case, courts are even more inclined to defer to agency interpretations and guidelines and the like. There are also a couple of instances where courts have affirmed HLC's authority to prescribe guidelines, including in a case, a 40B case involving a public body in Milton, and also in a recent Superior Court case involving HLC guidelines pertaining to housing authority issues under General Laws Chapter 121B. So I think ultimately, in my view, it would be likely in a legal challenge that the court would accord substantial deference to the guidelines. And, again, insofar as the authority to promulgate these guidelines is explicitly conferred in the statute, I think that that's also, a compelling fact for purposes of that analysis. So I'm happy to, that sort of summarizes the essence of it. If there's any more particular questions, I'm happy to address anything.
Let's go to Zoom first. Do we have any hands up? They always get called second. No? All right, Jay.
Okay. Hi. Thank you. I have some experience working with regulations, but not necessarily state of Massachusetts. And can you just speak a little bit to what is the difference between either in this specifically or in general? What's the difference between regulations and guidelines? Because I'm used to regulations. I don't know anything.
Yeah,
about
I guess the fundamental or main difference in my mind, anyway, and regulations are assigned a code of Massachusetts regulations number. It'll say, like, for example, 950 CMR 32 is in subsequent provisions is the series of regulations associated with the open meeting law. So basically they're assigned a number, whereas guidelines aren't formally assigned any particular number, but they'll be, formally adopted. It's also sometimes, sometimes those terms are used interchangeably, kind of in, casual, even parlance, even by judges sometimes, that, but basically, fundamentally, the main distinction is that regulations are given assigned numbers in the Code of Massachusetts regulations.
Can I ask a follow-up? Because there was one of the sentences in your memo made me wonder about this more. It was when you're quoting all these citations, and you quote one that says, an agency's guidelines, although not carrying the force of law as do properly promulgated regulations, is entitled to substantial deference.
Right.
I think your point was it'll get substantial deference, but I'm still wondering, does that mean if these were regulations, they would be the law? And if they're guidelines, maybe they're not the law, they just mean we're going to lose if we get sued?
Yeah.
I don't.
Yeah, by the way, 950 CMR 32 those are the regulations that govern public records. Easy to.
I wasn't gonna.
So anyway, but anyway, I'm not suggesting that that guidelines have the same legal force as regulations. I think that is how regulations are understood. They're given legal force and effect. That's not to say they can't be challenged, and a party couldn't challenge whether regulations veered afield or beyond of authority that was statutorily conferred.
Okay.
So yeah, I mean, regulations are assigned a number, and I think they're consistent with that authority that I cited in my memo. They carry the force of law, whereas guidelines don't. But again, guidelines, courts, afford or accord agencies, particularly where they've been statutorily, commissioned to promulgate guidelines with a lot of deference. And as a practical matter, I think courts will defer to agency interpretations of laws that they're charged with enforcing as a general matter, even if those interpretations aren't set out in formally promulgated or adopted quote unquote guidelines.
I'm still a little confused, but I'll stop and let other people ask questions.
Tom.
Thanks for being here, Town Council.
Sure.
So guidelines are not the law. Is that fair to say? When I say law, I mean a statute passed by a legislative body, right?
Right. Yeah. No, guidelines are not they're not, a statute is something that the legislature has voted to adopt.
Yeah. And the legislature alone can delegate legislative authority if they so choose, correct? And they can also delegate authority to promulgate regulations, correct? And authority to promulgate guidelines.
Yep.
Correct. And as to the guidelines, is it fair to say, Town Council, that that's a policy determination made by the agency, correct?
A policy determination. I mean,
I'll correct it. I'll make it a better question. That's a bad question. So essentially, to bear down on it, we have a law passed. The agency receives the law, and that agency then promulgates, those guidelines on how they think you should navigate that statute and get approval, correct?
So, well, in this case, what the statute said, I'm paraphrasing, but it said that the HLC shall promulgate guidelines to determine whether the municipalities complied with the act.
Yeah.
So you can, this precise language that the legislature uses in conferring that authority can vary, but in this case, it said, you all have copies.
Yeah.
Okay, yeah. So it says, yeah. DHCD or HLC, in consultation with a couple of other agencies, shall promulgate guidelines to determine if an MBTA community is in compliance with this section. So again, in some cases, a statute may say DHCD shall have authority to promulgate guidelines, not inconsistent with the section. The precise language that's used is different, but.
Yeah. And but they didn't give them the authority to promulgate regulations.
They didn't use the word regulation.
So there's no CMR about any of this. It's simply guidelines.
Yeah.
And so my question is, I think, better asked, is as administrations change, correct, policy changes, correct? For the most part.
Yeah.
And
that can happen.
Yeah. And as a result, the guidelines can change.
Yeah, DHCD or HLC could modify its guidelines, absolutely.
And that and there's public comment and there's internal discussions and evaluation of a situation, but when a guidelines change is going to be made, but that's a far easier process than changing a regulation, correct? And even less burdensome than perhaps even making a statutory change, correct?
Yeah, a statute would, I guess it depends on the context. I'm not sure there's a one-size-fits-all response to that. It depends on the context, circumstances of the matter. But I wouldn't get too hung up, in my view, in the context of this legislation and what the Attorney General's office has said about it, both, through a memo that I attached to my memo to the planning board, as well as, informal commentary from the municipal law unit. In my view, and as I said to the planning board, you can parse this out, copiously, but in my view, in the event of a legal challenge, if this is before a court, and that's what we do as lawyers, we're appraising risks and predicting outcomes. I think in a legal challenge, a court would accord HLC deference in construing these guidelines and interpreting the guidelines and determining whether an MBTA community has complied with the law, or the extent to which compliance with the guidelines and compliance with the law is the same thing, or can we deviate from the guidelines? I think that a court would. That it's more likely that a court would accord deference to HLC's interpretation on this issue and enforce the guidelines ultimately.
Sure.
But that's you. So, whether you can draw any conclusions from the fact that 3A vests HLC with the authority to promulgate guidelines and didn't use the word regulations. I mean, these are all legal arguments that would be raised in a challenge like that. But my judgment is as I explained to the planning board, in a legal challenge, I think it's more likely most courts would defer to HLC's determinations and its interpretation and its guidelines.
Sure. And Council, I just raised that because last year we had a meeting about Article 97 of the Mass Constitution and guidelines. And we had people stand up at town meeting and tell people that guidelines were the law. So I want to clarify that.
Well, I'm not going to say the guidelines aren't the law. That's not what I'm saying.
Well, I'm saying, so when I look at the law, I look as a statute drafted by the legislature, passed by the legislature with a penalty. So I'm saying I'm looking at a law, not a reg, not a guideline, nothing that's affected by policy or an election or politics. That people were saying a guideline was the law. And as a lawyer and a member of the Warrant Committee, I was troubled by that. That's what I want to. That's what I think people in the town need to understand.
Right.
That guidelines can change. That regs are written, drafted, and approved, and it's conferred by the legislature, and then the legislature writes the statute, and that is the end all. So that's why I'm kind of like going down this road.
Yep.
Because I think the town needs clarification, and town meeting needs clarification.
Yeah. So I think when you're determining, when you're appraising risks, determining next best steps, you have to consider legal authority, I think is probably the more appropriate phrase, which comprises lots of different sources of the law,
Yes.
Court decisions, regulations, statutes, guidelines, rules, policies. For example, if you're opining on a question relating to a public body, one of the things you need to look at is whether the body has a quote unquote policy on the question.
Mm-hmm.
And you need to evaluate the effect of that and what that means.
Yeah.
And that may be something that may have been adopted very informally, but it doesn't mean that it's not enforceable and that it's not something you need to consider in connection with the legal analysis.
Mm-hmm.
I think whether you want to undertake the exercise of parsing out what these terms mean and how different courts have defined these words. The reality is in some cases you might find some inconsistencies. Some of these terms may have been conflated or used interchangeably. The bottom line, when you boil it all down, is it's my judgment that in any legal challenge that attacks the validity of the guidelines or DHC's authority to promulgate the guidelines, I think that a court is going to, accord deference and defer largely to the terms of the guidelines and what HLC's done. That's my view.
Sure, it's fair though that the courts also get a little concerned when you're delegating legislative authority, right? Because you have essentially conflict in terms of separation of powers, right? And the SJC, the Supreme Judicial Court of Massachusetts, they have a balancing test, correct, to see if guidelines even fit the statutory scheme. So even the Supreme Judicial Court of Massachusetts says, as to guidelines, and that's the Chelmsford case, I believe it's Chelmsford Trailer Park Association v. Chelmsford. It's a 1984 case, and they talk about that, don't they? And I think because they're nervous about these guidelines. So that's why I just want the answer, because in terms of, is the guideline the law? And that's why I'm asking that. And I keep going back to it because, like I said, guidelines can change. That policy, they could be politically driven. I don't know, but it's not the law. And that's what I really want to. And I understand all that you're saying, and it makes sense. And I know that deference is given at some point by courts if there's a legal challenge. But I just.
Well,
if I'm making.
Yeah, no, absolutely. No, you are. You're making sense. I understand perfectly what you're saying. I would not say that the guidelines are not the law. It's a relevant source of legal authority, an enforceable and binding source of authority, in my view. I think the AG's office would probably take that position. Let's put it this way, and I don't know, we're sort of at the beginning of all this, this whole process, this whole regime. How are these bylaws going to be handled by the AG? That remains to be seen. Largely, they've opined on a couple of them, but where the AG deals with a bylaw that doesn't comply with the guidelines, how will it proceed? I don't know. I don't have a crystal ball, but I don't think the AG would say, well, you don't have to comply with the guidelines. In fact, I know that the AG takes a position that they're enforceable and binding, and has threatened to pursue different types of, legal proceedings and enforcement mechanisms against non-compliant communities. That's the whole substance of the memo that I attached to the memo to the planning board. So, so I don't think it's accurate to say, that, or to suggest that these guidelines don't have legal effect or, aren't, don't impose requirements that are legally enforceable.
And so I guess I don't mean I'm monopolizing this. Does anybody want to chime? I'm so sorry.
Why don't you finish it up? Go for it.
So
Then we'll go to Allison.
So I guess just like skipping it, and that's why, and this is just the questions I have just in reading the statute, because when I initially read the statute, and I read the enforcement and all that, I'm thinking this is an opt-out. This is an opt-out statute where it's saying like you will not qualify for certain grants. So I'm trying to think in my head what enforcement mechanisms are going to be employed other than, because there's nothing within the statute itself that's an enforcement provision as defined by, as how you define an enforcement position. So I'm just trying to think, and I know we're in the early processes, and that's why I'm concerned, because it's such a massive change to our zoning in the town. And, I know Rockport is sued, I think the town of Holden is. So, when we're looking to make these giant changes, there's such uncharted territory. Mm-hmm. That my concern is that we do these zoning things, huge zoning things, and then we find out a year later, the court says, start all over again.
Right.
This is unconstitutional. So that's where my head's at, counsel, when I'm asking these questions.
No, it's perfectly valid questions and concerns. I mean, one of the problems is we're under a time constraint, right? So that makes it difficult. We don't have the luxury of time to let the process play out and see how the Rockport case, about which I just learned recently. I'm not sure that's, I don't think that's been the subject of any dispositive decision. I think there might be some dispositive motions before the court. So I don't know where that stands procedurally. We'll see how that's decided. Of course, it's a Superior Court case, so that may, whatever the decision is, it may be appealed. But the memo, just to be clear, in case you don't have a copy of it in front of you, it does say, this is from the Attorney General's office. It says, all MBTA communities must comply with the law. Communities that do not currently have a compliant multifamily zoning district must take steps outlined in the DHCD guidelines to demonstrate interim compliance. Communities that fail to comply with the law may be subject to civil enforcement action, and then it goes on to enumerate other potential penalties
that aren't in the statute.
Well, the non-compliant or the ineligibility for certain funding opportunities, which you mentioned. They also suggest in this memorandum that communities may be subject to claims under the federal and state fair housing laws and the like, any discrimination laws. So the AG definitely is, and I don't want to go, I don't think we need to get into the particulars of all of the universe of claims that might be available to a party if they wanted to challenge, the town's bylaws. But my only point is the AG's office definitely has taken the position that these guidelines are enforceable and I think pretty clearly intends to take a hard line in aggressively enforcing the terms of the act.
No, that's fair. It'd be very interesting to see how creative they can be and how the courts will respond. Mm-hmm. For me, from my perspective, because it's going to be very interesting how they enforce this. From my reading of the statute just on its face. But I thank you, Mr. Chair. Thank you, Town Council.
Sure.
I really appreciate it.
Oh yeah, anytime.
Allison was next. She's on Zoom.
Hi, thank you. So I'm a little concerned listening to Town Council. I really appreciate your feedback, but if the town decides to wait a year to see what other towns do, what would your argument be to HLC that supports the town's decision to wait? Because listening to you, I just have a little bit of a concern that if we decided to wait, like your response would, we would want you to take the position of supporting the town and what they decide. So can you just elaborate on kind of like what you would do to support the town's decision? And I thank you very much.
Oh, sure. So I'm not sidestepping the question. I don't think it's prudent. Look, my fidelity is owed to the town. I'm going to zealously represent the town and serve its best interests, which, depend on the circumstances. If the town were in a position where they needed to defend against a claim of noncompliance with the MBTA Communities Act, obviously we would, zealously defend the town's position in that case, whatever arguments needed to be made and vetted, and we would work exhaustively to defend the town's interest. It wouldn't be prudent for me to discuss in the context of an open meeting what the strategy would be in a case like that, or what the legal arguments would be. At this point, the question we've been asked to opine about is basically the one I've described having made to the planning board. What is the effect of these guidelines, and what would it look like if we didn't comply? Are they enforceable? But in terms of what would lie ahead for the town if it didn't comply, or how we would defend the town in a case like that, I don't think I think it probably extends beyond the scope of this discussion.
I just have a
It
follow-up
wouldn't be something I would address, other than through a privileged memo to the client.
Allison, you had a follow-up to that?
Yeah. Like if the judge makes a ruling, how often would the judge kind of like deviate from the stated penalty in the statute?
So I'm not sure I totally understand the question, but I guess the short answer is that it's the universe of scenarios that might arise, or how a court might decide in a particular case or circumstances is impossible to predict. I mean, it all depends on what the issue is in the case and what the particulars of that specific case are.
There's only 3 grants, correct?
In the statute, she means.
statute.
In Part B of the statute.
Enumerates.
The statute lists 3, but the new guidelines have 13 or 14, I think.
Yeah. So again, the AGs, if what you're asking is what enforcement mechanisms would be available or would be exercised against the town if it were deemed not to be in compliance by the Attorney General's office, that's laid out in a memo that I attached to the memo to the planning board. And I just quoted an excerpt from it a moment ago. The AG has underscored that it could pursue civil enforcement action. So to be clear, the statute isn't an opt-in or opt-out proposition. It's not, well, if you don't comply, that's fine, but you won't be, the only drawback to that is you won't be eligible for these funding opportunities. That's not the case. The statute enumerates, it makes clear that communities that don't comply will be ineligible for those funds, but it doesn't relieve the community from compliance. The MBTA communities, Section 3A mandates compliance with its terms.
Are you good, Allison?
I just had one last question. Thank you so much. Is there a process to, like, when we change the guidelines for the public to weigh in? Like, do they have a hearing to weigh in when we change the proposed guidelines in that at all?
So offhand, I don't, that's more of a Karis question. She was more intimately involved with the HLC's process. Basically, HLC did did afford interested parties and the opportunity to submit comments, and it was sort of a months long public vetting of the proposed regulations, but the precise practices or procedures that HLC follows in promulgating guidelines, I don't know offhand. That would be something that Karis North would definitely.
So with each change, there's nothing that is, where anybody is allowed to provide any process for the public. So they're able to make changes.
No. That's not what I said. I said my understanding is that there was again, my knowledge of that is more peripheral. Karis would have more intimate familiarity with it, but there was like a process through which, for example, the Mass Municipal Lawyers Association submitted comments on draft guidelines. It was a pretty protracted, window within which these proposed guidelines were being vetted and parties were submitting comments on them. I just don't know. Like, for example, how many public meetings they had, where they had them, and how many opportunities members of the public had to submit questions or comments on the proposed regulations or guidelines, rather. I don't know that as I sit here. I'd have to. That's something that Karis is much more involved with.
Okay, thank you. I appreciate it.
Sure.
All right, we're gonna go JJ, then Tim, then Dave. JJ?
Thank you, Chair. Thank you for coming and talking. I really appreciate it. So I just want to ask on the statute, Member Caldwell brought up, and he's a lawyer, in case you didn't know, but just by his comments, you probably did. But basically, he asked about the statute, and you just stated that in your opinion, in the statute, it is not an opt-in or an opt-out situation. The statute clearly states that, we have to implement this plan. We have to follow the guidelines, basically. But Member Caldwell reads the statute and thinks differently. And, I'm not a lawyer, but he's a lawyer, and you're a lawyer, and you're our counsel. I guess I'm just wondering what part of the statute, is there specific wording that you can point to that says that it's not an opt-out situation, that the only penalty would be losing those funds?
So the word "shall" is normally construed to impose a mandatory obligation, unless there's some case law that says something, paraphrasing, but the word "shall" should ordinarily be construed to impose a mandatory obligation unless the application of that proposition in a given circumstance would produce an absurd result, which I don't think, would, in my view, would be the case with respect to this statute. The statute says in its first line, an MBTA community shall have a zoning ordinance or bylaw that provides for at least one district of reasonable size, and it goes on from there. So I don't think, and again, the Attorney General's office clearly interprets this as a mandatory obligation, as something that MBTA communities have to comply with, and that would be the state agency that would bring an enforcement action for a violation.
Okay, I understand that, and thank you. I guess what I'm wondering is because, Member Caldwell was talking for a while, and I just want to, I think it would be important to the town to be clear on this fact. I'd love to invite Tom to speak on this and just say, with respect to that word "shall," Tom, does that change your opinion on this?
Answer the man.
Well, when I read the statute, I see an MBTA community. That's if you opt in to being one.
Okay.
Without an enforcement provision, it reads as an opt-in statute. An MBTA community if you shall decide to be one, you shall do X, Y, and Z, and not go halfway. And if you do everything in these guidelines, you get these funds. So I think that would be, Member J.J. O'Connor, that would be my point.
Okay.
And I think that's, and again, as I mentioned, town council, just the uncertainty as to all of this. The guidelines have changed since the statute was first passed. So that's kind of, JJ, that's where I kind of began from the Jump Street.
Yeah, now I understand what you're saying now. I guess what I'm wondering then is the letter that the select board sent and we just got a ruling on today, I think, is that basically now we are an MBTA community? Like, we have no choice. We are an MBTA community by virtue of that letter. I don't know if the town council, can you address that?
There's no question that Milton is an MBTA community.
Right.
I think you may be referring to the town status as a rapid transit community.
Okay, yeah.
So I think that's been the state's interpretation.
So I just to be clear, because I just want to make sure, because we are an MBTA community by some legislative body saying we are, or is it, how did it happen that we became an MBTA community?
We fit within the definition of an MBTA community in the statute and in the guidelines.
The statute and the guidelines?
Yes.
Is that right?
Yes.
So the statute, I think from what I remember reading, it said there are 12 communities, and because we satisfy certain criteria, we're along certain rapid transit lines, therefore we are an MBTA. Well, that's a rapid transit community versus an MBTA community, is that right?
JJ, Jay's pulled it up. In the Act, there's actually in the definition section 1A of the Act, it defines an MBTA community as a city or town that is one of 51 cities and towns is defined, et cetera, et cetera, et cetera. So what they've done is they've looked at the MBTA, looks at who is served by the MBTAs, and have given us this designation as an MBTA community. It's kind of like a legal designation, okay? So we've been identified as being subject to it. And then there's the further clarification on the issue of whether we're rapid transit or not, because they further divide the MBTA communities into these various types of other communities that are making us subject to different densities, potentially, and deadlines, right? Because rapid transit's done this year. Okay, so we are an MBTA community as defined by the Act.
Okay.
I think this was before the Act.
It was even before the Act. So they took these definitions from another Act and incorporated them.
All right. So, sorry, just want to make sure, because now that's great. Now, Tom, does that change your opinion of the statute?
What I'm reading here? That we've been designated?
Basically, your previous objection was that it wasn't a valid binding statute, that it was an opt-out. You said that, yeah, the shall has validity, but I don't think we're an MBTA community. But now, according to what various people have just said, we are an MBTA community. So I'm just wondering, does that change your reading of the statute?
Yeah, JJ, but the thing is, though, my whole thing is, what's the consequence?
Okay.
There's no penalty, JJ. It's allowing you to opt out of grants. So whether or not, so that's, I think, what I'm trying to understand here is when I'm looking at it, and no one seems to have the answer. What's going to happen? The legislature should be very clear, I think, in telling you and pointing the prosecuting authority, whether civil or criminal, what they can do and what they can't do. So when I'm looking at this, that's great, we're an MBTA community. that's great. We've been designated rapid transit. That's all great, but what does it mean in the end? So I accept the designation as the community, but I just don't. The legislature is silent, thus being an opt-out. We opt out because we don't get the grants. So that's I'm not reading one sentence or paragraph. I'm reading it as in its entirety.
Okay.
And I think it's unfair to take a snippet of a statute and then try to deconstruct it. That's just my opinion, and not read it as in the whole. So I don't know, JJ. That's just my 2 cents.
Yeah, I would recommend, if you haven't done so, or you probably have, but I would take a look at that Attorney General memorandum that was attached as exhibit, because it's pretty explicit about that issue, and the enforcement mechanisms that office would pursue against MBTA communities that it determines not to be in compliance.
Yeah. And I understand that. That just my previous comment just surrounding just how they would actually go about doing that and how the courts would react to it. I think, again, huge unknowns. So for me, it's speculation.
Yeah, no, I definitely want to delve into what the potential consequences are for non-compliance. I guess I'm just wondering, like, because I haven't read the statute, and I'm not a lawyer, but I know, I just wanted to make sure your interpretation is basically like there's no consequences. That's what the opt-out is. But you think that this language, because we are an MBTA community, because it has the word shall, like the town council is basically saying those two facts combine to make this that we have to comply. And I know what you're saying about the consequences, but let's say there was a law that said you have to cross the street in the middle of the road, and there's no consequences, they just say it, then that would be it, I think, right? Is that, I'm trying to make a valid analogy, but I'm just trying to say, like, I guess what the town council is trying to say is this is law.
Yeah. So I guess, Mr. Chair, if I could just say in terms of the comment as to that, it's just, when I said that there's just so much uncertainty, there are lawsuits right now, and I think the courts are going to give some guidance to the Commonwealth and the cities and towns on how we should proceed. So JJ, my questions I think would be very similar to maybe what a court would have when they're looking at this initially. Maybe not. I'm not a judge, but so that's what I mean. That there's not a lot of answers, and I think the enforcement. How they're going to go about enforcing it, and all the other things we're raising now, I think would be answered in due time.
Yeah. No, I want to hear about potential enforcement too. And I have more questions on that, but I cede the floor. Thank you both. Thank you. Appreciate it.
Right, it's Judy. It's going to go Tim, Dave, then Judy. And Julie. Tim.
Yes. Question on the memorandum from the AG's office. On the second page, the first paragraph, the first sentence, it ends in guidelines to demonstrate interim compliance. What is interim compliance?
Interim compliance is something that, again, this is something that probably could be better addressed to Karis, but it's you can seek a determination from HLC that that you're pursuing, compliance, or that you have.
In other words, we're doing it in good faith, but we're not able to fully vet everything to get to a full compliance.
Right.
So there is an alternate route then, according to the AG's office.
And this is something that the guidelines address. Again, this is a specific question I defer to Karis, or this is something I could more explain in more detail if, other than extemporaneously, if I went through the guidelines, I could define, because the guidelines actually address what that term means. Yeah, I don't want to. I can review the guide. I don't want to hold up the discussion, and we can jump back to that in a second.
Right. I mean, because that was actually going to be my question as well. So it looks like Tim and I are on the same sheet of music. I mean,
just to be clear, I don't think the town could miss the deadline and not face, potential sanctions or repercussions from HLC and the AG. If that's the question, I think the town would miss that deadline, or communities would miss the deadline at their peril.
right.
I don't think it's missing the deadline. They're saying there's interim compliance. So there's interim compliance somewhere. We're in good faith trying to get everything through without being detrimental to the town. And they've changed their guidelines once. Who says they're not going to change it again?
I mean, since he asked my question, I'll just sort of make a comment that's in that vein. I think a lot of what I sense is the searching that's happening is that, like, Pete, what you talked about in the beginning is risk. It's like this is a bet. We're making a bet. You ask 20 lawyers, sometimes you get 20 answers. I do criminal defense. If no one's going to jail, you're playing with house money.
But, okay, so this is an important point on this question. The time frame for interim compliance. This is all laid out in the guidelines on page 16, and I don't want to read verbatim from it, but basically, I'll summarize. Prior to achieving district compliance, and many MBTA communities do not currently have multifamily zoning district of reasonable size that complies with the requirements of Section 3A. Prior to achieving district compliance, but no later than the deadline set forth in Table 3, these MBTA communities can achieve interim compliance by taking the following affirmative steps towards the creation of a compliant multifamily zoning district. Talks about the submission of an action plan, HLC approval of an action plan, implementation of the action plan. To achieve interim compliance for grants made through the 2023 one-stop application, action plans must be submitted by no later than January 21, 2023, which obviously is long since passed. Having just recently come aboard, I don't know the complete genesis of at least the town situation. That's something that maybe Tim could address, or Karis may have some familiarity. Perhaps she worked with Kevin on that. The point is that we're already past that point. Right now, we have a deadline of the end of this year to promulgate compliant zoning. And I think I understand the point about there being some uncertainty with respect to how courts ultimately would adjudicate a challenge. I think that's fair. I mean, we don't have a crystal ball. We don't know how a court will decide. The Superior Court may say one thing, and it may be turned around on appeal. But what I can say, I think, with a lot of confidence, is that HLC and the AG would take a hardline position and I think pursue enforcement against the non-complying MBTA community. So how that type of enforcement action would ultimately shake out, we can't predict precisely, of course, but I do think that it's pretty clear that if the town were to miss the deadline, that it would run the risk, and I think a pretty material and extreme risk, that it would be subject to some enforcement from the AG's.
But we just authorized $400,000 to plan a school that may never get built. So, what's the first retainer? Part of the frustration is that as we've been sitting here watching this, waiting for it to happen, it's just been kind of framed as a narrative of its compliance versus non-compliance. There is no alternative to non-compliance. But like Tom was saying, part of what gives this law its effect is the or else part, or else. And we're really trying to get a good sense of what's the or else. Like I said before, like I have these conversations all the time where I lay it all out and my client just says to me, yeah, I get all that, but am I going to jail? And if the answer is no, let her rip. So that's part of what we're really trying to get. And I know it's hard to nail that down because to Tom's point, you just don't know until it happens. We just don't know until it happens. We can meet the law. We can have, I don't think there's anybody in this town right now who's saying, seriously, don't do zoning. I think most people are saying do the zoning, but there's 2461, there's a 300, and there's a 900. And I think that people are kind of looking at, what's the line on this? What's my hedge on this? What are the odds? Maybe I feel more comfortable with the 900. If we go to 900, we meet the statute, so we have zoned. Then the question then becomes, well, if you're not compliant, how hard are they going to come for us? I think that's a lot of what people are trying to wrestle with here.
I think we're probably veering a little bit
Okay.
beyond the confines of the discussion at this point. This is a more of a preliminary conversation. We don't have the committee's not dealing with specific proposals tonight.
Right.
Some of these questions, I think are probably more appropriately addressed by Tim, or, maybe it would be more prudent to make the subject of a more fulsome,
And we will have those for sure, yeah.
So, but I will, again, bottom line is that I think that if for the town not to comply, or the town to receive a determination from HLC, because again, these bylaws, once adopted, have to go to HLC for approval. If there were a determination that it was a non-compliant bylaw, I think the town would, would violate the act at its peril. I do think it would be susceptible to some sort of enforcement proceeding. I think that in a court's review of the matter in connection with any proceeding like that, I think that the court would defer to HLC's interpretation of the act's requirements and the guidelines. I think it would be an uphill battle from my perspective. That's how I sort of appraise, or forecast,
right,
what that would look like.
Thank you. Judy, you're next.
It does, I think, go to compliance, and I'll stand corrected, but because the town is petitioning that we aren't categorized correctly as a rapid transit MBTA, because we only have 4 trolley stops, so that's different designation. While it sorts itself out through the system to be redesignated if it's going to happen, and we didn't meet the 12/31 deadline, would it be fair to say that we're trying very, very hard to be compliant, but we think we've been miscategorized, therefore we can't meet the deadline for the one you gave us because we think this is the one we should have, which I believe has a different timeline? Anyone help me?
Right, but Judy, I think that we just
We just did
said,
that?
They just gave us their determination. It came out like
Just today.
today. Did you?
Oh,
get
I
it?
did not, and I apologize for not being up to date. What did they say, please, if I may?
Well, we don't have good news.
Yeah.
Oh,
We would
well,
have led with that.
maybe I should have left early. Well, I wasn't at my computer all
Yeah,
day, so
I can get you the letter.
Oh, I was gonna.
So basically,
In the
paraphr-
business journal, I read
Oh,
it,
you got
but
it,
I just didn't.
could someone paraphrase this? We are not,
We're
not,
rapid
yeah.
transit.
that's it.
That's it. It's over.
And we're on the red line.
Go figure.
Go figure.
There's still a planning board letter to,
Okay.
an I don't know if it's HLC.
Oh, it was,
or-
I don't know whose copy this is.
Planning board letter's still out. To one of the groups.
Oh,
Okay, Judy, does that answer your question?
Yes, so that, if I could clarify, because we don't have this, option anymore to have a different designation, then 12/31 is it?
Right.
Okay, thank you.
Ron, it's going to be Julie, and then we'll go to Ron. Julie Joyce on Zoom.
Hi, thank you. I just had a quick question. All this talk with the MBTA, obviously this development push is a transit-oriented development push. The reason for this is they're trying to get people to utilize the red line, and the people that do utilize the red line to get them closer to the city. Has anybody discussed a limitation on allowing cars to be registered and insured moving forward, if this does happen, to limit the actual additional vehicles on the road coming in and out of Milton, because we're already so strapped with the traffic as it is? If this is truly supposed to be MBTA development and transit oriented, I would think that limiting additional vehicles to any of these parcels would make sense. Thank you. That's a question. Thank you.
I think that question, we should hold on to that for when we have maybe Tim in here, or they're making the actual presentation on the plans, because I think I need to take a little bit of my own medicine. I just sort of rambled on a bit myself, or I'm not saying that you're rambling on. I think I was out just off the issue of it's getting late.
Compliance.
Thank you. So I know that there have been discussions to some degree of those issues. We can definitely ask those questions when we have our presentations. Do you have any other questions, Julie Joyce?
Nope. Thank you.
Thank you. Ron.
Council, thanks for coming, and thanks for sharing the thoughtful documents. I had one question. So when we're talking about risk and what is risk of noncompliance, can you talk a little more about the AG's letter, specifically footnote 8, where they kind of tell communities what are the repercussions beyond the funding? They talk about they can pursue civil action, and specifically they talk about declaratory judgment.
Right.
Does that mean they would go to a court, hypothetically speaking, and ask for an enforcement action? They send in a National Guard? Is that the type of threat that looks like?
I don't know about the National Guard.
I'm being dramatic, but
Right.
No, I mean, I think that the point of that footnote is to again bolster the point that the AG is making, that in addition to what it calls administrative consequences enumerated in the statute, that it could pursue injunctive relief or an action in a court in which the AG would ask the court to make a declaration or impose some order, some requirement via a court order to direct the town to comply, perhaps potentially impose other types of sanctions. Again, what that might look like precisely is they don't really copiously describe, but injunctive relief is sort of, a catch-all. There's a lot of, the Superior Court has broad injunctive powers. So I think that the AG would, my sense is, exhaust all means of, available relief to enforce compliance with the act.
So hypothetically speaking, could they ask a court to designate a decision maker to make zoning decisions for this town and take us out of the picture totally?
I don't, I mean, you can ask the court for whatever you want to ask the court to do. And again, the court has very broad equitable powers to impose requirements and in different types of relief. That specific request, I don't know. I personally haven't heard anyone, propose that. But again, I think the AG would, and they have a lot of smart lawyers in their office, would exhaust all means of making whatever request they had to make to ensure that they could secure ultimately the town's compliance with the law. And I think that they would do that, vigorously and emphatically.
A couple questions. Thanks for coming.
Sure.
If we pass the zoning, 2461, and we did everything in the transit area as is kind of the whole point of the zoning, and the guidelines change in April of next year, and they say you can do the zoning anywhere in your town because it truly isn't going to work out to be transit oriented, but we've already gone full steam ahead and things are happening, development's happening. What would be our recourse and what could we do then now that we've zoned everything to, that area? And yet now we have the opportunity to really spread it and be more thoughtful because this is a big event for our town and all the other towns, cities and towns, that's going to cost a lot of money to the taxpayers. And we might it's just, and now we're going to jam it in this area, and we could have been more thoughtful because the guidelines changed again. What would we do?
Well, you can always amend a zoning bylaw. I guess that would be, if based on future developments like a court decision or guidelines, there was a feeling that the whatever bylaw ultimately gets adopted could be modified, then the means to do that would be amending the zoning bylaw.
And this, I think, has come up a couple of times in many of the meetings. The zoning bylaws, are they a 50% majority or is it the supermajority?
So as a general proposition, zoning bylaws require a 2/3 quantum, but this bylaw would be a majority quantum.
And what makes this bylaw different?
Again, probably appropriate for a more fulsome analysis, but it encourages, housing and, density.
Isn't it part of the statute? Part of it is it part of the laws? My understanding, please correct me if I'm wrong, was that they put in the law that this would be a 50% majority if the zoning is in the transit corridor. Because it's true.
So if it's outside of it.
So they're wrestling with that, I think, at the planning board, is that there might be plans that they're working on that might take a 2/3. But so.
Yeah. So it would depend, the quantum would depend on the language. It's not something necessarily that could be answered in a vacuum. It depends on what the language is and
Who decides that?
what the quantum is. Well, you can get a determination of that from the state and, council. That's ultimately a decision that usually council opines on.
So,
Hold on,
And
go ahead.
I have one other question, or one other
Make it fun.
thought. So we need to be compliant by December 31st
Right.
from the guidelines. In order to do that, wouldn't we have had to have been at town meeting in May in order to have the time to then submit the bylaw to the Attorney General for their review to come back?
No, the vote needs
Vote
to have
alone.
occurred by, right.
And what happens if the vote happens to be no and it doesn't pass? Then
Right, then the town would be non-compliant.
as a follow-up to that, if theoretically it was a no vote at town meeting, would we have to wait 2 years to bring it back? Because there's some articles that if it is a no vote, they can't bring it back again. Would this be the kind of thing that would happen with?
Right, that's I haven't considered that. I'd have to
Okay.
give that some thought. I mean, that is in the zoning act, there's language to that effect. And there are always questions about whether the proposal is the same. Of course, you can get by that with, it's set out in, I think, section 16 of the act. There's a vote that I think the planning board, I'd have to go back to the language of the statute. There's ways to
Ways of,
circumvent that
Okay, good.
prohibition. Yeah. So
again, not expecting that to happen, but just as we're sitting here looking at risk. What's the risk of non-compliance? What's the risk of a no at town meeting? How quickly could we bring it back? Judy, you were next.
In terms of the quantum, just because I'm confused at the moment about compliance, some of the zoning is the simple majority, and some of the zoning that the town came up with is 2/3. At the town meeting, will they differentiate those? We're going to call this Zone A, which is a simple majority, and now we're going to do what we're going to call Zone
It's
B.
my understanding they're taking a really hard look at that.
Okay,
A
thank
very,
you.
very hard look at that because it's
Could be very confusing.
and it could be. It's going to be a tough issue.
yeah. So I think it's, again, we'll see what the language says,
Right.
and that all will be ironed out for a town meeting. There won't be any confusion about what quantum will apply to a particular vote. But I think we need to see the language.
Right.
May I have just a
Sure.
quickie follow-up? So in a hypothetical case, say it does split in our town to simple majority and a 2/3, what could you see happening if one quantum passes and the other quantum doesn't? How will that affect our compliance? See what I'm saying?
Yeah,
Trying to
no.
make so in other words,
I think it's,
the town meeting is doing its best to be compliant.
Yeah.
One passed, one didn't, because we had to split the quantum. We don't really have time to have another town meeting before December 31st. And so do we fail compliance, or are we going to get credit for almost there? Do you follow my weird?
no, I think I wouldn't want to get too bogged down in hypotheticals. I'm not trying to be evasive. I think, look, when the language is set, any confusion or questions about the quantum, I think we'll have an opportunity to iron out and to make very explicitly clear and crystal clear for everybody. And I wouldn't worry too much about different hypotheticals that like the one you're describing. I'm not really.
I would hate to, I think compliance being the discussion this evening, it would be odd to be non-compliant just because we had to split our vote and one made it and one didn't. Okay, thank you.
Thank you. Tom?
Can I ask the chair a question if I'm out of
Okay.
scope regarding initiation of articles?
Yeah, I think, right.
Okay, I'm sorry.
Let's keep it to, right, compliance. We'll
Sorry.
definitely be looking into that.
Sorry. Okay.
Right.
My apologies.
Thank you. JJ?
On the question of compliance and potential consequences, I'm just wondering, this is a hypothetical, but it has a real world example, I guess. I'm just wondering if we didn't comply, could this follow the path that 40B seems to have taken, where, with 40B, we're not in compliance as a town, so developers come and they buy a lot, and then they propose, a big development, and then the town of Milton has hearings, but inevitably it might go to a court, and the court will basically force some kind of compromise or some, development there. I'm just wondering, in this case, if we were in compliance, could a developer buy someplace that was near a trolley and, a single family, and then propose a 10 unit, and then Milton says no, and then it goes up to, the courts, and the courts say, well, you're not in compliance and you should have 2461 units, and this is going to help you meet that requirement, so it gets approved. And I'm just wondering your thoughts on that.
Yeah, so the court, in the absence of a bylaw, basically imposes the requirements of the act.
Yes.
With respect to a particular project. I suppose it's possible. I don't know.
I guess I'm asking a big hypothetical question there, and it seems like you said it's possible. I guess I'm just wondering, is that what happens with 40B? That's kind of a real world example. Is that like, we're not in compliance, now we're going to force you to be in compliance through the courts and judgments? Is that what happened with, is that in your opinion what's happening with 40B right now?
Well, I don't, 40B again, it's a little, I don't want to veer too far afield. 40B is a statute that provides for an expedited, essentially, more of a one-stop shopping, if you will, approval process for qualifying projects that, I may be missing the question. I mean, I guess that's whatever relief a party would seek in a 40B case would be different from this hypothetically you described. But again, I don't want to get too bogged down. The bottom line is, if the town were found not to be in compliance, or if the AG, they didn't have a compliant bylaw, if HLC made a determination that the bylaw wasn't compliant, or if there wasn't a bylaw by the deadline, I think the AG again would take very active enforcement.
No, I hear you on the AG, and I tend to agree with you there. That letter seems like pretty clear to me, but yeah. I'm wondering about other avenues of consequence, right? Like
the parade of horribles.
Yeah.
Yeah, no, that's I think the courts have broad equitable powers to, issue orders that impose sanctions and requirements, and ultimately, I think you could be as creative as you want to be about how precisely what that would look like or how a court might go about that. I think a court is, going to, the terms of an order, if the town were found not to be in compliance, I think would incentivize compliance or mandate it. How exactly that would, what shape that would take, I don't know.
Can I point out to the committee, it's 9:15 and we do have another agenda item on our agenda tonight. So I think Jay had his hand up first.
Okay. Yeah, I'm just still trying to wrap my head around what it means for a town to break a law, essentially. So, there are three parts of this law, and the second one says, well, if you don't do it, you won't get these grants. I'm guessing there are a whole bunch of laws in the state of Massachusetts that say towns shall do this, towns shall do that. And I'm also guessing that not all of those, well, I don't know, I should ask you, are there laws in the state of Massachusetts that say towns shall do this and that, but don't have a punishment laid out and that we still follow? I mean, to my mind, we follow the law because we follow the law. I don't know.
Sure.
So,
yeah. So lots of laws and many laws that use the word shall. I will say this. I think, again, I mentioned this at the outset of the discussion, but I think it's noteworthy is that in this statute, there's actually explicit language that confers upon HLC the authority in conjunction with the MBTA and DOT to promulgate guidelines to determine if an MBTA community is in compliance with this section. So I think that would be noteworthy to a court if a court were to adjudicate a question like that. It's pretty clear HLC, the AG have taken the position that this communities don't have discretion to avoid compliance with the terms of the act, and that in the absence of a compliant bylaw, they would pursue enforcement. So I don't think that it's, again, anything can happen in a court proceeding. Until an appeals court of the SJC says otherwise, I think it's pretty clear that, to me, from my perspective, that MBTA communities have to comply. They're required to comply with the terms of the act.
okay. Yeah, I guess I've heard, when listening to various meetings, I've heard two arguments. One argument is we have to follow the law, but we don't have to follow the guidelines. And other people argue we don't have to follow the law because all we care about is these grants. And, again, it makes me wonder. I assume there's tons of laws that the state of Massachusetts tells towns what they have to do, and we do it because the law says we have to. And do they all have punishments written into those statutes, or?
No.
Okay.
Not necessarily.
Okay.
Again, it's a.
So there are other laws that we follow because the state says you have to.
Right. And, it's not unusual if, for example, a bylaw in Massachusetts, as you all, I'm sure, are aware, the Attorney General's office, municipal law unit, has to review all bylaws after they're adopted. And it's not unusual for the municipal law unit to determine that a municipal bylaw runs afoul of some state law. And it may be a law for which there's no explicit, sanction for noncompliance. You'll sometimes see language that says we strike, this sentence from the bylaw as noncompliant or as in violation of some state law or constitutional provision. A court could conclude that some law or some bylaw requirement is unenforceable, or I don't want to get into the dissertation on the home rule amendment, but municipalities have broad authority to craft their own rules and bylaws, so long as they're consistent with the Constitution and state law. So, yeah, I don't know if that answers your question.
I think so. Thank you.
Tom?
I don't have anything, Mr. Chair.
Allison?
Going on the bylaw, I just have one quick question. If we, let's say, supposedly pass the MBTA at town meeting, but the AG finds the bylaw is incorrectly written because you're not writing the bylaw, or like we have not, attorneys writing the bylaw, what happens?
So the HLC, under the guidelines, has to determine whether a bylaw complies with the act. If the HLC were to determine that the adopted bylaw wasn't in compliance, then I think the town would be out of compliance, and the AG would, my sense is that could or would pursue some sort of enforcement action.
But this is approved by town meeting, so wouldn't.
So the language has to be, there has to be a determination from HLC that it complies with the MBTA Communities Act, that the adopted language is in compliance.
Have you looked at the bylaws to determine if you find I guess we haven't seen the article yet with the bylaw, but have you had a chance to look at those?
Yeah, so again,
Right, we don't I think at this point we're talking about compliance. I'd let the committee be aware it is now 9:21, and we have another agenda item to get to. Are there any other questions for town council? Thank you. This has been really important to us.
Yeah, absolutely. My pleasure.
Really important to us.
It was helpful for me too, to hear some of these questions and to get a flavor for what might arise or what kinds of questions might arise at town meeting. So it's very productive and helpful for me, and I look forward to working with all of you, with respect to this town meeting and in the future. So, and feel free to reach me anytime, and anytime you want to have me in, I'm happy to.
Thank you.
Thank you. Thank you. Thanks.
Thank you.
Thank you.
Tom. Thank you very much.
I don't make that request. All right, thank you. All right, the next item is the discuss and vote upon proposed warrant article with regards to the recording of elected bodies. Is
Ms. Kinsella?
she available?
She's still here.
Oh,
And she's a panelist.
can I recognize her?
Yes, I think she's unmuted. There she is.
Hi, thank you for bearing with us during our lengthy discussions. Could you identify yourself for the record, please, and share your concerns with the Warrant Committee?
Yes, thank you, Chair Humphreys, and thank you, Warrant Committee. I appreciate you taking the time to listen to me tonight. And thank you, Chair Humphreys, for allowing me to read the letter to the Warrant Committee and explain a little bit about what the board discusses in our meetings. So I'm just going to read the letter. Dear Warrant Committee, this is a letter of concern regarding the new bylaw to require video recordings and postings of meetings of elected bodies, elected public bodies. After further reflection pertaining to this potential new bylaw, the Board of Health and the Milton Health Department staff have concluded that video recording and posting of Board of Health meetings may be detrimental to the mental health and well-being of residents and may have a negative impact on business owners. The Health Department is in a unique position to uphold and enforce state and local public health laws. Board of Health meetings cover a wide variety of public health matters, including tenant and landlord disputes, evictions, neighbor disputes, animal sanitation, trash and debris, compulsive acquiring tendencies, also known as hoarding, food establishment violations, environmental complaints, and other mental health issues. Milton residents may be hesitant to video record a problem or sensitive issue that they may be struggling with in their life or home, which will be recorded forever for everyone to view. This would limit the Board of Health and the Health Department in serving the community. Currently, the Board of Health posts the meetings and the public may attend virtually or in person. Currently, our meetings are virtual. And the Board of Health posts the minute meetings on the town website. I asked our community health social worker, Ann Grossman, to share an impact statement. She said the health department works with very sensitive issues with regards to housing and mental health. These are sensitive areas for residents, and residents may not trust the health department anymore if they know that a recording of a meeting is able to be resent and viewed more than once. This creates an opportunity for other residents to talk about these sensitive issues. Occupants and landlords may be hesitant to bring concerns forward and not fully trust the health department. And I'd like to say that for some residents, discussing their sensitive issues at a Board of Health meeting may be traumatizing. And if it's videotaped, it can be continued to be viewed, further exacerbating a situation. And I'd like to reiterate that the health department and the Board of Health are not in favor of video recording of the Board of Health meetings. Thank you.
Thank you. Does anyone have any questions for our guest? Jay has a question.
Last week, or whenever we discussed this, I believe it was suggested that such sensitive areas may be taken into executive session. Do you have any thoughts as to if they could be taken into executive session, if that would address these concerns?
Oh, thank you for that question. So executive session, I did reach out to Pierre Mello, our new town council today. I've never spoken to him, but he did give me a couple of minutes of his time. And he did send me an email afterwards about executive session, which had a lot of legalese in it, and I really couldn't understand it. Legally, to my knowledge, if we were litigating something or if it was a legal matter, we would go to executive session. I fear that we would be, or I would be, contacting town council much more often to find out if we can be speaking about matters in our Board of Health meetings. To my knowledge, we only had one executive session a number of years ago, and that involved condemning a house, which ended badly, unfortunately. It was condemned and sold and then raised, and the occupant was very upset. So that was a bad situation all around for the health department and for the occupant. But I think we'd have to be discussing a lot with town council to find out if we could actually go into executive session, because so many of these matters are sensitive to people who bring them up to the Board of Health or the health department. At that point, we're talking about unsanitary conditions in the house, neighbor disputes, and then this is going to be videotaped, and that can be passed around after the meeting, sent to other neighbors, and it just can be out there forever. And that can be damaging to people.
Pete?
So yeah, I totally dependent on the context and the circumstances in any given situation. Obviously, that goes without saying. But I think that bases that might be available to the board in connection with discussions like those Ms. Kinsella describes might be purpose one, that allows a board to meet in executive session to discuss complaints against individuals or I pulled it up on my phone. Purpose one allows a body to convene an executive session to discuss the reputation, character, physical condition, or mental health rather than professional competence of an individual, or to discuss the discipline dismissal of or complaints or charges brought against a public officer, employee, staff member, or individual. The purpose that Ms. Kinsella mentioned, I think she probably was thinking about the litigation, purpose 3, which allows a body to meet to discuss pending or threatened litigation in certain circumstances. That would be an example of a purpose that usually involves counsel. There's a statutory catch-all. Purpose 5 pertains to the investigation of criminal allegations of criminal violations, criminal misconduct, or to consider the filing of criminal complaints. I guess conceivably that could apply depending on what the violation is. There's also a statutory catch-all. I'll call it a catch-all that allows a body to meet in executive session under what's called Purpose 7 to comply with or act under the authority of any general or special law or federal granted aid requirements. So if there's some statutory basis to meet an executive session, that could be available. So that I think it all depends on what the issue is, what it involves. Executive session isn't something that I would encourage bodies to get to convene in freely or without. You should make sure that there's a basis for it and a proper basis for it. But I think depending on the circumstances of a given case, there are a few different purposes that a Board of Health could invoke to go into executive session.
Any other questions? Jay?
I have, Ron, go ahead.
Ron?
So it sounds like there's a legal basis for the Board of Health to go into executive session. But is it that it's a practical concern that they just won't do it because that's not the nature of how they work? And I think that's a question for
Caroline.
Yeah, Caroline.
I'm sorry, I couldn't hear the question if you're speaking to me.
Sorry, my mic was not on.
I'm sorry.
So I think there's legal grounds for the Board of Health going into an executive session under one of those 7 or 8 purposes. But is the concern that, just practically speaking, the Board of Health doesn't use that mechanism or wouldn't likely be able to use that to protect the privacy of people coming to the board?
So we have not used that mechanism. I only remember that one time. A lot of times we don't know exactly how it will go with our meeting. I mean, what we post, it could get very contentious at our meetings. It can put some residents in a bad light. Some businesses it could put in a bad light. We're just thinking of the mental health of the residents, the community at whole.
Got it. Thank you.
Thank you.
Judy?
Would it be fair to say that at least half of your meeting could qualify as being of the nature to protect privacy? You would have to be in executive session?
Yes. Sometimes our meetings are like housing complaints, tenant landlord complaints, evictions.
Thank you.
Thank you.
Jay.
I'm not sure if this is a question for town council or for the Board of Health, but maybe more for town council. The bylaw as proposed has certain exceptions, executive session being one of them, site visits being another one, just because you're walking around a park or something. We discussed last week about the possibility of adding another exception. I think, and I don't know if, did Mr. Milano get you in this conversation and propose some wording?
I've seen the language, but I think those, so I'd have to go back to the language, but those carve-outs address discussions that aren't subject to, it basically, it applies the requirement to open session. So if in the case of a site visit, for example, so long as there's no deliberation, the open meeting law exempts site visits from the terms of the open meeting law. Executive session, obviously there's I guess I shouldn't say obviously, there's a provision in the open meeting law that allows members of the public to film open sessions. You just have to tell the chair, and the chair announces at the beginning of the meeting. So any open session discussion can be recorded by a member of the public or anybody. So the carve out for, you don't have that right with respect to executive sessions. I guess you wouldn't have a right with respect to a site visit, because site visits, again, provided there's no deliberation, aren't subject to the open meeting law's requirements. So I'd have to go back to the language of the bylaw to see exactly what the carve-outs are.
Okay, but I think we're discussing the option of proposing an additional carve-out that would say something along the lines of items of a private personal nature outside of a general public interest as determined by the committee chair and identified in the meeting agenda. I think I sent that to Mr. Milano, and he sent it to you to say, would this be appropriate bylaw language?
Yeah, I don't have a specific memory of seeing that language. It doesn't mean that,
that's fine.
It doesn't mean I didn't. But I looked at I looked at the bylaw, a draft of the bylaw at some point.
Okay. I guess I don't know if this is a question or a comment, but I don't know, would something like that, I mean, that might address the concerns not only from the Board of Health, but also from the cemetery trustees. Sorry, I guess that's not a question for you. Would that be appropriate to write into a bylaw?
As I'm hearing it, I'm not sure there's any prohibition on language like that. I mean, I guess as a practical matter, again, if it's an open session, there's a right to record by a member of the public.
Yep.
So if the bylaw were proposing to prohibit the recording of meetings in that scenario, I think there might be a problem there. I think the AG might, cast sort of a jaundiced eye on that, or but if that's not the case,
no.
I guess before I would opine on something like that, I'd like to see it in print and make sure I'm not missing anything. But you're saying the carve out would just allow the chair to make a judgment call if during this meeting it was anticipated that there was going to be some discussion about sensitive matters, the chair could unilaterally determine that the recording wasn't necessary.
I think that's the idea we were kicking around last week.
That's the gist of it. I guess I'd have to look at it, but I don't think that. Look, there's no state law that requires a public body to record the meeting in the first place. So I think language that relaxed the requirement wouldn't run afoul of any state law. But I could take a look at that.
Thanks.
I can share. I got an email from Deborah Milbauer this evening. I'll read. She presented to us last week, and she's coming back with regards to the concerns on the subcommittees. She says that she shares the concerns of the board of health, the trustees of the cemetery about personal privacy. She says this as a solution, and so we don't eliminate non-resident related agenda items. She says she thinks executive session is a good option. It doesn't require tweaking of the language, so she's reiterating that. I think she brought up the last time. She mentioned this to me on the phone. I called her to see if she was going to be here tonight because she had asked me to reach out to her to let her know our schedule. It was late, and I just called her and just talked to her briefly. She just reiterated that she felt that that while the subcommittees in theory are a great idea to include, she just seems to think it's not logistically feasible at this time due to capacity.
Talking about the subcommittees.
The subcommittees, correct. Subcommittees. And that, one way of doing it would be on a case-by-case basis. Like she mentions, for instance, we had brought up school budget subcommittee, that it could be possible to bring it out. Like if we had, members of our warrant committee who were going to those meetings, we could bring it out. We could record those. Anyway, she asked me to share that with the warrant committee. Lori.
Wasn't Nick going to discuss it with the select board tomorrow night? That's what he said.
Oh, I think you're right.
Which part of it?
He's going to bring it up or something. Run it by him.
Although I think there's some confusion on the subcommittees. When I mentioned originally the subcommittees, my specific concern was if there is a subcommittee of an elected body, so the select board has many subcommittees that are only made up of select board members. That was what I was thinking. If the planning board had a subcommittee of MBTA, then I would want them to be recorded as well, because they're elected bodies. There's a subcommittee of them still having an open meeting, but just record it. Not necessarily us going to, and I don't mean us because we shouldn't be recorded, but every subcommittee that's out there. I would think that we would be looking at other boards and committees that are appointed to make them be recorded instead of every single subcommittee out there. But if you're in a subcommittee of only elected officials, that was what my original intent was when I mentioned subcommittees, because they're elected officials, and that's the point of the bylaw that she was proposing. Just to clarify my position.
It's good.
Okay. Right.
I have one question for council. Have we looked at any concerns from a wiretapping perspective? If there are if these meetings have members of the public who come to raise concerns and we're forcing it to be recorded, I guess, and they don't consent.
Sorry, let me repeat that. Have we looked at this recording law in light of wiretapping laws? And I don't know what Massachusetts' wiretapping law is, but when there are members of public who come to these bodies and we're saying we're going to record it, if the member of public doesn't consent, then are we saying that they can't bring their issues to the meeting?
Yeah, it's an interesting question. I guess I don't see, in the context, especially of you're in a public place and at a public meeting, there's a state law that, as I mentioned, gives members of the public the right to record. I don't think there's a viable wiretap type claim or a claim by a party that they didn't give their consent to being recorded in that context. It's an interesting question though, but I'm not concerned that a bylaw like this would pose any material risk to the town or render it susceptible to a claim like that.
Okay, thank you.
Sure.
Okay. Where are we going with this? We
Did
got-
I understand we were not going to vote this evening? Okay.
What do we
I don't
was
know.
gonna say the same thing, because I wanted to hear back from Nick.
want to hear back from Nick?
And
Okay.
I also, so
Yep.
then I made a whole list of the committees, boards and committees of elected officials, and just to look at them, I mean, Deborah came in with, her list,
Yep.
and maybe there should be more, maybe there should be less. I don't know. I just think there may be some more.
Can you take the lead on that, please? Because, and by
In
lead,
terms of, I didn't have time to finish. I was gonna go through this more, and then I would share it.
right? Because there had been some, in some of our conversations, there have been sort of like one of the possibilities that sort of had been floated out there was maybe instead of saying like subcommittees are going to be recorded, that there would be a few that would be named. Like that had kind of come up, that there might be some that we're interested in, but not others. Like, so if we're going to be making a list of those, can you sort of take the lead on the list?
Sure.
Right? The list is life. All right. And then, so when we get back around, we're going to have to move fast.
Yeah.
Because we're talking about Monday,
It's
Tuesday,
shrinking.
Wednesday next week, MBTA hitting. If we're going to be drafting,
It's shrinking real fast, our time.
Tom.
Halloween. Will
Oh,
we
that's
be meeting
right.
on
No, we're not
Halloween?
meeting. We're
How
not-
many people would we be missing if it was Halloween? I'm not, I don't want to get into,
If we call it Samhain, then it's a religious observance.
Monday.
So
Then we would have a discrimination lawsuit. You're discriminating against people with young children.
Right.
You would.
I know it's an important night. I've done it
All
several
right, all
times
right.
with.
We
Can
went
I-
through this the last time. There was people who said I'm not going to be there, and it was
Period.
enough to really
Okay.
cause quorum
Okay.
to be an issue. And
Okay.
so, right,
Perfect.
Can I?
Jay.
So it seems like there are two issues. There's the subcommittee issue and there's the personal privacy issue, which maybe we have different feelings around the table. I think the personal privacy issue is the bigger one to tackle. Other people may feel differently. Do we think, and here's a proposal for the personal privacy issue. If we put in language like I just read, or if somebody has better language, pretty much saying, if it's a personal issue, the chair can say we're not going to record it. If we put that in now, and I don't want to set us up for, well, here's what I'm proposing. We put it in now. It is late October. That gives town council a whole month to say, I get what you're saying. Here's a better way to phrase it. And then if town council has a better way to phrase it, we put out a green sheet at town meeting. That's not the end of the world. So I mean, the personal privacy issue could tank this whole thing. So if we're trying to avoid tanking this whole thing, put in another exception, personal privacy. Mr. Chair, you can phrase it as best, I can come up with wording or anybody else can come up with wording. That will keep this whole thing from failing. And then if town council gives us better wording in December, we use that better wording. And we do whatever we want to do or not want to do with subcommittees. Are there nods around the table? Is there?
Who? Amanda, then Ron. Amanda.
Hi. I think what Jay was just talking about, I feel like that's already covered in the open meeting guidelines that town council was just talking about. That point number one, the 10 permissible reasons for entering executive session, because I think that would cover different groups, different committees where that was an issue. So I don't know that we need to go to the step of pulling out language when it's already noted.
Do you have anything more to add to that, Amanda?
Nope, that's it.
Thank you. Ron?
I think what I heard from the Board of Health was executive session would still not be a good solution for them. I think that is another concern, Jay. So I'm not sure if we would need to address that as well. Or do we just tell the Board of Health, you need to go learn how to get into executive session? I don't know if we want to do that.
I put myself, were you going to respond?
I'm just not sure if I'd follow what you said. I mean,
No, you go.
I think when the Board of Health representative was speaking, they were saying that half the meeting could be private in nature. And I would think that topics come up and it may not be feasible for the board to immediately decide to go into executive session, then out of executive session, then back in and out. I think it's a practical issue that the type of work that they do, it's just not conducive to that.
well, I think
structure.
there's two ways we can go. We can not change the proposal from that we got, which would be what Amanda said, and tell them, guys, you got to go into executive session if you're talking about personal stuff. Or there's what I'm proposing, which is they don't have to go into executive session if they're discussing personal stuff. If they're discussing personal stuff, they can hit pause on the recorder and discuss their personal stuff and then hit pause again when they're not discussing. So what I'm saying is give them a way to put pause on the recorder without going into executive session if it's personal and not of public interest.
I put myself on the list and then you'll go, Judy. A couple things. I'm just going to go. The thing that gives me pause with regards to Jay, your plan, is the discretion to make that determination by whoever the chair is. You know, as we're all well aware, is that, you know, chairs routinely abuse incredible power. But it's a discretion thing, and it's tough to have a guide. It's tough to have a real guideline there. The power is one of the reasons why we have all these things, is to keep power from being abused. Something that she said on the Board of Health that really hit me, though, was when she was mentioning like evictions. Like it sounds like it's a simple routine thing, but if you've ever seen an eviction, and where people really get up there and just are talking about their lives. I mean, some of these hearings that they're talking about are really personal, are really, really personal. Where people talk about their pets, I mean, and I understand that it's public and people can go, but it's different when it's on the internet forever now in front of everybody and people can go watch it. And so, that really just, I'm going to say that kind of moved me a little bit, is that the hearings that they have, and when the people come in there and you really see what's going on deeply in the people's lives who maybe are very troubled, and while maybe it doesn't rise to the level of mental health, right? Maybe it doesn't rise to the level of mental health, but, that would tend me towards just adopting it as written and leaving the subcommittees off. If we really, then we'll put you on the list. If we, really want to be there, we can go, like the school budget, so we can go. Anyway, just mention that. It's going to go Judy, then Lori. Judy, and then the list online. Thank you.
To the question of the Board of Health having their meetings, and apparently any one of us can go down and listen. If they are on, I just need clarification. If they are on executive session, then no one can record, including the public. Would that be correct?
Right. Yeah. Members of the public aren't allowed into executive session.
Okay.
No,
So, but
no
if they're-
public body can record its executive session if it wanted to.
But it's not made public.
Yeah, there's rules that govern the release of information like meeting minutes and information used in executive sessions. Like once the purpose of the session is no longer applicable, technically there's a process through which a body will release minutes, in documents used in connection with an executive session, subject to redaction of privileged information, stuff like that. But
The privacy issues, like your name may be mentioned, my name may be mentioned, those would be redacted. Not necessarily.
Yeah, again, it depends on the circumstances. I'm just saying,
And if they're public meetings, I could go in, trust me, and just hit my camera on video or something, and there would be nothing to stop me from sharing it with people. So I think that goes to my question. How do we really protect the privacy of our citizens in these rather traumatizing meetings, issues, where it could rise to the level of mental health, but still be traumatizing to deal with? And how do we protect the integrity of this, the Board of Health? We want all of our boards and committees to operate with integrity. But at the same time, what would be a good solution for this? I'm so now confused. I thought I understood it, and I don't anymore. Because I agree with Chair Humphreys that, this isn't soap opera TV. I mean, these are real life issues affecting real individuals that really don't want to be part of town gossip.
Thank you. We're ready to go to Lori? Do you have more to add, Judy?
Oh, no, I think I expressed my thought process. How do we really? We've heard from 2 Board of Health people and Dave, and a lot of good comments from the committee, and it just seems I'm on the side of trusting our Board of Health to know that people's privacy needs to take first place. That's it.
Thank you, Judy. Lori?
So I raised my hand about the comment about the evictions, and then you said, so maybe we forget about the subcommittees, but go with the way it's written. That means the Board of Health is getting recorded. And I was confused.
I'm right there with you,
It
Lori.
seemed like it was opposite of what you were.
Bear with me. Right. So you're right. Thank you for that.
So is that what you meant, or did
What I meant is that the Board of Health I felt that the Board of Health should be excluded based upon their request, is what I should have said.
I thought that's where you were going,
But
didn't
I
say
didn't, because I'm tired. And thank you for catching it.
OSHA.
Thank you.
Reading OSHA, it's saying we must have a break.
Okay. And then based upon that,
I'm sorry.
Lori, do you have anything else?
No, I would like to table the vote till is kind of where I want to go.
Right. Okay. It's right. Okay. But I have people who wish to speak.
Yep.
Amanda, Allison, Caroline, and Kristen. Okay. Amanda.
Yes, thank you. I completely understand the sensitive nature of things, but I was just like doing a quick look at some of the past agendas, and it seems like there is a wide variety of topics that are covered. I think some of which could be of interest to people that aren't necessarily personal in nature or anything that would necessarily be, I don't know, for lack of a better word, embarrassing. And I think that I didn't realize the wide range of things that the Board of Health does weigh in on. So while I understand that there would be things of a personal nature and things that there needs to be sensitivity around, I still think I go to the idea of being able to go into executive session for these things, it seems like that first step or that first, 10 of the 10 criteria, there is some leeway around how to, interpret that from the standpoint of sensitivity, mental health, et cetera, that I think you would be covered for a number of issues, but it wouldn't prevent the public from hearing about other things that could be policy related or could be
Right.
relevant to people.
Thank you for that. That's a good point.
Thanks.
Thank you. Allison?
Do we have a list of how many towns records the health board? I haven't heard when they did this research any other I don't know if we've heard any towns.
Do we have any idea?
It's on my list.
Okay, Allison.
And then, if we table it, that would be great. And if, so that we can get that information, that would be essential. And just a reminder, these people, when these agendas are posted, they can still listen to people like they can phone in, they can listen, they can go to the meeting, right? So if it's, to Amanda's point, if somebody's concerned with listening to it, it's just it wouldn't be recorded. They would still have be privy to being able to go. Right.
Okay.
Record on their own.
I just wanted to, I'm concerned about, you can't just anticipate how things are going to go. So right. if the Board of Health saying it could go one way and they're on, I just I worry and bring this point out to counter, just because I think it's a very important point that was brought up by you, Dave, and Ron. You just can't anticipate how health and some of these discussions could go. And I worry that if we record, we could put two and two together, and that information, once it's being said, it can't go back. So just thinking of that too.
Okay, thank you, Allison. Do you have any additional points to make?
No, I agree with coming back to this. I don't think this is a good vote to take right now.
Okay, good. Thank you. Caroline.
Thank you. Thank you, Warrant Committee and Chair, for listening. I am Caroline Kinsella. I'm the Health Director. And I will find out for you how many other health departments in surrounding towns do tape the meeting. I think the concern was taping it and residents being able to see that in the future and it never going away. That could be detrimental to their mental health. And if something like that comes up, and we do, as I said, discuss a lot of personal and private matters, and it's hard to anticipate in our meetings, what's going to happen. As I said, it can be, very lively sometimes and contentious. And sometimes you just can't take things back when they're said. But I'll find out that answer about the other health departments.
Thank
If they
you.
do report. Thank you.
Kristen,
Hi, I just wanted to thank the Board of Health for coming tonight. I just thought it was really interesting to hear that perspective. I've only attended a few Board of Health meetings in the past and just, have not been really aware of the very sensitive issues that residents bring up at these meetings. So I just think it's important, we had a letter that the cemetery brought to our attention. They're the ones who deal with these meetings, week after week, month after month. And if they have these concerns, I just think it's something that we just really need to take into consideration. And I agree, tabling the discussion for now. Thank you.
Jay.
Yeah, I would not be a fan of a blanket exclusion of the Board of Health, because the Board of Health covers some public interest things and some private things. And, in the past couple of years, they were making decisions about COVID policy for the town. That is important for everyone to see and for everyone to follow along with. So I think if we put in an exception of, except for personal items, hit pause on the recorder before you get to personal things. Maybe even, I don't know, maybe they could even edit it out afterwards if they realize, oops, we recorded this and we really shouldn't have. I don't know how the nuts and bolts would go, and the trustees of the cemetery, I don't know what they do, but we vote for them. So I'd sort of like to see their meetings too. So I don't want to tank this whole thing because, I do want to be sensitive to privacy. And I think town meeting could shoot this down if it's not sensitive to privacy appropriately. So I'm coming back to putting in a exception except for personal issues, but not excluding the Board of Health. Thank you.
Lori.
I would just comment on this trustees of the cemetery, their memo that was written, referenced the trustees presently have minutes that are recorded and available for review, but there's nothing for the last 2 years, 22 and 23 posted.
You might try, you might try asking, because there are some subcommittees or some committees that don't post. And by law, our council will tell you they don't have to put it on the website, but they do have to provide them when you ask.
I'll ask.
So, yeah, I saw that too.
Okay.
So it's tabled.
Do we think the town is clear? Do we think the town clearly understands what we want them to discuss tomorrow?
Who's to connect with Nick on this?
Oh, my subcommittee issue? Yeah. Oh.
Your subcommittee issue, but you're not a subcommittee.
No, on the.
Because you would have to post an agenda, right?
He would have, he was gonna discuss this.
Okay.
What do you, I'm sorry.
As long as he knows
I think
that.
I'm confused by what you're asking.
No, thank you for doing that. No, I'm confusing you. Thank you for talking to Nick about these things that we needed to have figured out.
Subcommittee humor.
Subcommittee humor.
I got it.
Yeah, you got it right.
This is very serious stuff. No
Yes,
humor.
right. Deadly serious.
Not laughing.
And not to kill a good time.
Right.
Do we need a motion
Okay.
to table
Yeah,
that?
yeah. I make a motion to
Another-
table this, and will someone second it? To table this article until it is on our agenda properly at the first available meeting. No.
Do we need a motion?
Do we need a
Or
motion?
can I just suspend it?
We can reconvene. No, that doesn't really work
What?
either.
Yes, town council.
What's the best thing to do? Do we have to make a motion to table it?
Because we're not voting.
Yeah, no, I mean, I don't, unless there's any procedural requirement to that effect.
I think we're
don't
just
know.
tabled it.
I mean,
It's our common practice. Our common practice is, all right.
So are we sure Mr. Milano knows what he's discussing with?
Okay, Jay, what's on your punch list of things that he needs to?
I have no idea.
Do you know what you need to talk to him
Well,
about?
he said he was going to take the subcommittee to the select board. So my comment around the subcommittee, I was kind of specific about what I wanted. I think it grew bigger in this discussion to have all sorts of subcommittees. I don't think that's the case. School committee, I hear, is big, and that makes sense because it is the budget. So
Finance.
I would ask him to talk about the elected bodies subcommittees that are just theirs, as well as the school subcommittee. That's kind of what I would be asking about.
So you're trying to find out like what are the big subcommittees that we're talking about?
Yes, I think it's.
Yep.
But again, from my list, I think it's the select board is the one that has the subcommittees, and then the school subcommittee.
Yep.
School committee, finance, subcommittee.
Yep. And then sort of like looking down the road, what we might gonna be doing potentially is making a recommendation to language that's just different from what's here. That would be to the effect of potentially just this language that Jay's talking about or something like it.
That one sentence.
Yeah.
Which he already sent to Nick.
Which he already sent to Nick. I mean, are we talking about more major changes than that? It sounds like we're just doing an assessment to figure out what we're talking about. And then the possibility of kind of like a one line, one red line, or just one change. That's kind of the scope of what we're talking about, basically.
I mean, there's one change for the privacy issue, and I don't know if there's going to be a change for the subcommittee issue. That's why.
Depending.
But
that would mean that I would think.
But that
could. Going to talk to them about having them rewrite their article.
Oh.
They've done that
Okay.
before. Do you know, like the 4 o'clock?
Okay, so that's the request.
Yeah,
Is do they want to rewrite the
notifications
article?
we get from them?
So we're talking about asking them to rewrite their article?
I think that's what he was talking about. If they would entertain that, and if they agreed, the select board on Tuesday night, if they agreed to the subcommittee being put in the following elected public bodies.
Yep.
Whether they're the full board or a subcommittee of the elected board.
Okay.
Is what I'm looking for.
So that change might be made by them.
Potentially.
Okay.
Their agenda for tomorrow has them opening the warrant, discussing MBTA, closing the warrant, and then they discuss everything on the warrant. So it doesn't seem to be, I don't know if that precludes them from like changing the wording of their proposal on this item.
Jay, if I may. Last year, how many meetings did we come in before town meeting? Well, there were only 3 town meetings. I get it. We would come in and we would get the 4 o'clock notice from the select board that whatever article, and we had to vote on it. And then there were times we had to vote on the floor. Oh, that's the 7 o'clock notification from the select board. I only mention that because I have seen it happen. And we had to vote at the last minute because things got changed at 4 o'clock in the afternoon. I know I keep saying that.
Can we get back to this? So
based upon that agenda item, if they're talking about this as a warrant article, can Nick not bring up the fact that the warrant committee discussed X, Y, and Z? Is that, I don't know if that's an open meeting law violation because it's just the article and he's talking about our conversation that we had with him last week.
Oh boy,
I just,
tricky.
as long as Nick is very clear about what you want him to talk about, what you want him to talk about, that's all I want. I don't want tomorrow night's meeting to come and go, and then we wanted Nick to talk about this, but he actually talked about that. That's all I want.
You can talk to him if you want.
I don't.
We can go together.
But don't call yourself a subcommittee. So play it out. You'll do great. And it's baked, and it's going to be what it's going to be. If there's not adequate notice, you can't do it. You can't do it. Like play it out. It'll be what it's gonna be. Right?
Yep.
Thank you. Amanda,
Is there clarity? I guess I'm not 100% clear on when we're talking about the subcommittees and the list that's being pulled together and shared with the select board. It sounds like there's a filter being used as to what would be recommended. Does that make sense? Like, it sounds like we're not saying every subcommittee of the elected boards, but if we're not saying that, then what's the criteria by which we're using to say they're not applicable? Does that make sense?
Lori.
So, Amanda, my original thinking was as it turns out from my list, the select board has what appears to be, and I would confirm with Nick, 4 subcommittees that are made up of elected officials, the select board members. So in my mind, if we want to record all elected public bodies, we would record whether they're in their full board or in a subcommittee, if it is just those elected individuals. In addition, there was discussion about the school committee because it's such a large amount of money of the budget. That would be the school committee finance subcommittee that we would add to that. And maybe we need to have a vote or a discussion, a broader discussion to get agreement that folks are okay with that.
So can I follow up then?
Yes.
So I guess my question would be, if I understand correctly, I think, there's like a couple of other subcommittees within the school committee that would still,
you're absolutely,
I would imagine, be of interest to others that aren't necessarily just about finance, because they're talking about curriculum, they're talking about other things. So I guess that would be my only question is how we're I guess what's the criteria for narrowing it, as opposed to if it's all of the select board subcommittees, why wouldn't it be for the other elected boards as well? There would be all their subcommittees.
I think that's a great point, and that those subcommittees are not listed under boards and committees on the website. So when I pulled the information, I didn't have them. And again, these guys brought up the school committee tonight, so I can go back and look on the school's website. And I think that is an accurate, I think you are correct, and we should add those committees as well. Because my again, elected public bodies, whether they're the whole board or committee or a subset of them, I would, yes, want recorded.
Great.
Per this article and what is being presented to us.
Great. Thanks for clarifying.
Is that what you're asking?
Yeah.
We should have.
Yes, that's what I'm asking. Yeah, because I just don't want it to seem arbitrary, and that it should, it feels like it should stay with the intent of what the original article was, which is about, essentially transparency with elected boards.
I agree.
And so the same should apply to all, it would seem, to all subcommittees within those elected boards.
Thanks for pointing that out. Again, it was not on the town website. It's got to be on the school website. So
great.
Thank you.
Allison.
I'm good. Amanda touched on the subcommittees and Lori, so that's good. I'm good. Thank you.
All right, thank you. So I had put an agenda in for Wednesday. You basically had everything on it. Until about 5 minutes ago, I was thinking we probably weren't going to meet on Wednesday because I don't think MBTA is going to be ready for us. because we put it like, it's like, it goes a little like this, is that planning board and select board are meeting tomorrow, Tuesday. It's very uncertain, like what is going to come out of that. You know, I am thinking that what we'll want to do is kick MBTA when we kind of know what we're looking at. Because, like, let's say we get a presentation with regards to the select board article. I think that we would have questions for that presentation based upon the other articles to compare it with is a way. Also, because they're having the presentation of the select board article at the planning board on Thursday, it would be, I would imagine, an identical proceeding. So what my suggestion would be, we just go to that. And then we can groove off the questions that the public has and see that, okay? But do we do this on Wednesday? Is there enough time for all this? Because this would be the one thing, like we could focus on this on Wednesday if we think we can get these answers.
Okay.
So the question was, it sounds like we're tabling it, we're getting ready to adjourn. Do we meet back on to bring this up on Wednesday?
Will the info be ready?
Would you think we'll be ready?
Will the information be available? Do you think, Lori?
I mean, they're meeting tomorrow night, so.
Okay.
And let's play it out. Like, let's say,
They say no subcommittees, just as written.
or there was a disconnect somewhere and it's not on their agenda and they can't do it because whatever, open meeting, right? Do we have enough to go on our own without their feedback?
Only if they're going to take a recommendation to
So we could
alter
always
some
make
of
the call at the
language.
last minute.
Yeah.
See how it plays out tomorrow. See how it goes. So be prepared to meet on Wednesday, please. It'll
Mr.
be a
Chair,
last.
Is there any other issue that's on the agenda? Because hopefully you gave us a wide berth to pull into. That we can sort of knock off the list.
Well, the other one that I had on for Wednesday was the transfer of parcels of land, which was the very first thing we talked about with regards to the conservation land transfer of parcels of land, that we could hold that vote again. I don't think that'll take too long.
So in other words, our time wouldn't be wasted. It could conceivably be a very short meeting, yet get our duties and agendas shrunk a little bit.
Well, it is possible. I mean, if we knocked recording of elected bodies out and have the final vote on conservation land, then the only matter that remains before the Warrant Committee going into the special is MBTA.
So we could have a short meeting. We're all done.
Just cursed us.
And
There's no way we're going to have a short meeting now. But it's possible.
That's all promise not to ask questions. No, I'm sorry.
All right.
It's late. I didn't get my OSHA break.
So we're good?
That's so.
Is everybody good on Zoom?
Yes.
Yes.
All right, we're good on Zoom.
Yes.
Yep.
Yep.
Is there a motion?
Motion to adjourn.
Seconded?
Second.
Is there an opposition? It carries.